Appeal is allowed.
You have next question.
Appeal is allowed.
May I appeal, Your Lordship? Lordship, I'd like to mention item number 6, Lordship, with the consent of the other side also.
Yes.
Lordship, may fix any other date, Lordship. He has some personal difficulty.
But he's there in item 2. He's not going to be here in item 2.
Lordship, in item 2, Lordship, the appellant's family of the appellant, Lordship, furnished one school certificate, Lordship, wherein, Lordship, his date of birth is 3/7/2003. And Lordship, as on Lordship, at the time of occurrence, Lordship, his age was 16 years, 11 months, 18 days. Lord. So, Lordship, I
Plea
mean,
of juvenility is being taken.
Lordship,
We'll see.
Lordship, I need 1 week time, Lordship, to file and bring the
Yes, okay, you want to file an application.
Lordship.
In item 6, you're right. A general prayer has been made on behalf of Mr. A. Kari Chaudhary, and its senior cast for the effort. And the same is not objected to by the learned APP. This is the matter. When?
Any date, Lordship, after a week, Lordship.
Give a date. Yes, right. As per the office note, notice has been served upon the respondent. Correct?
Lordship.
This is the matter. Okay, that. Then in the item 2, right? Mr. Ayu Chaudhary, the counsel for the appellant submit that the appellant would like to file an application on the plea of juvenile, as the appellant was around 16 years,
11 months, 18 days.
11 months, 18 days
Lordship.
at the time of the incident. So the matter pertains to conviction of the appellant under section 4(1)
Lordship.
of the POCSO Act. List the matter after 2 weeks.
DP of my Lordship.
Yes, what are you working as?
Presently unemployed, my lord.
Unemployed,
My income is based on rental income.
rental income.
Yes, ma'am.
You've got house.
Yes. One BSK flat, my lord. That was given on rent, my lord. 10,000 I used to get the signal.
Okay, 1 BHK flat where? Location?
They are in Azara,
Azara.
outskirts of.
On the way to the airport.
Yes, ma'am.
Near the police station.
Exact,
Where?
exact location, my lord.
That is a growing township.
Anyway, but one BSK necessarily 10,000, cannot be more than 10,000.
We don't know. We don't know whether you've got only 1 BHK. Whether it's 1 or 2, so according to you, you cannot pay 6,000.
No, my lord, because
How much can you pay? It's not a question of whether you're going to pay, it's a question of how much.
ability to pay, my lord. How much? No.
You're getting 10,000 according to you.
4,000, 6,000, but that isn't fixed by the court, my lord. So can it be 4,000?
When did you marry?
Marriage took place, my lord, in 2017, my lord.
And when did you
Separation took
separate?
place 18, my lord.
Any children?
June, my lord.
So what your only ground for challenging the interim maintenance is that you have got one BHK flat
Yes,
from which you are getting rupees 10,000 per month.
yes.
Is that true? That is the only ground.
That is around grand, but moreover, she is earning more than me, my lord. She is earning around 30,000 per month.
Earning as what?
She is a HM, my lord.
Huh?
Human Resources Department, my lord. This is
She's not the department.
department, my lord, private company, my lord.
She's working in a private company.
Company, yes.
As what?
As a HM executive, my lord. There in their statement itself, she has stated so, my lord.
Huh?
In a declaration before the court, my lord, the assets and liabilities, my lord. There she has stated that she has been earning in 2024 around 30,000.
That's all? Anything else?
Basically, on the result whether ability to pay, my lord, because nowadays, because of this judgment of the Supreme Court in Rajneesh versus Niham, they says you have to file assets and liabilities. And the court has to consider the assets and liabilities of both the parties and determine that.
It will determine when it makes the final decision.
In
Right now, it's saying
interim maintenance also that the decision says that you have to take into consideration all these factors.
if it is filed, have you filed?
Yes, we have filed, but the court below did not take into consideration all these aspects.
And in your affidavit before the Leonard Family Court,
Yes, ma'am.
what was the stand taken by you is that you have got rent of only 10,000.
Yeah, 10,000 is the income, my lord, that I have.
That is the only income.
Yes, ma'am.
Whole day you're watching TV otherwise. What do you do? And you wait for the end of the month.
Actually, my mother is a ailing person. I have to look after. So that
So you are 24 hours by the side of your mother.
all along I have to stay because he is a
Where is your mother living?
in Guwahati, ma'am.
In Guwahati. In her house,
In our own house.
in her own house. Where is your mother's house?
Mother is our my residence, my lord, that is at South Sarania, my lord.
South Sarani,
Kastuba Nagar, Ulubari.
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 And who's living with your mother? You're looking after your mother.
Yes, we are.
Only you.
Yes.
Only you are looking after.
Yes.
No one else.
No.
So only you and your mother are living together.
Yes, ma'am.
Have you got any brothers, sisters who can look after?
The sister already married, my lord.
And no brother.
No brother.
No brother. So only one sister.
Mhm.
Sister is married.
Married. She's staying in
Living
Calcutta.
with her husband.
Yes, ma'am.
Sister is married, living with her husband.
At Calcutta.
And in Calcutta. With husband. And no brothers. One sister, no brothers. And the house is your mother's house.
Yes, my parents' house actually.
Parents' house is your mother's house.
Mother's house.
Father is still alive.
No, expired. No.
So it's mother's house.
Mother's house.
And you've got no share in your mother in that house.
Sorry, I will get you after he expires, my lord. The salary will come to me.
And what kind of a house is it?
It's Assam type house.
Assam type house. Oh,
Whole house.
whole house. Good compound.
I cannot say.
Anything else? Any shop, something? How is your mother surviving? What is her source of income?
Pension benefits used to.
Pension. Your father was serving as what?
He was comment of that exactly. I cannot say, my lord.
He will be doing.
I'll take instruction. He was a government employee, he expired.
Expired by exactly how much he is. That part we don't know. So basically, our case is that let the court decide, my lord, trial court, my lord, regarding after going through the assets and liabilities.
Okay, one thing,
Yes, my lord.
you were supposed to be paying this order for interim has been issued when?
It way back in 2000, your worship time,
2023.
2022, 23, my lord.
31st August 23,
Yes, my lord.
correct?
Yes.
Have you paid?
Yes, no? Yes, been paying
You have been paying.
regularly.
You have been paying regularly.
Sometimes the default is there, but occasionally, but
So you have been paying from September 23. You have been paying regular. You have been paying. Now, why suddenly?
suddenly, actually, we file an application because at that, what has happened on this, there was on 31/8/2023, that application interim order was granted. Man. Prior to that, there was a direction of the court to file assets and liabilities, both the parts.
That's
And-
all right. That's all right. But from 31, from September 23, you have been paying. correct?
Payment, yes, madam. Now, subsequently, what we have, then we made an application before the court, my lord, for recalling of the order on the ground that since my income is only 10,000,
But was there any stay of the order of 31/8/23?
no stay, my lord. So subsequently, there's another order which is under challenge, that is 35/2024.
Huh? 3/5?
2024.
And what does that say?
That says, but they had rejected my application on saying that I'm a able-bodied person, so you have to pay.
That is nothing. So the 31/8/23 is still surviving.
Still for that.
Have you paid the entire amount till now? Any area?
Yes, Your Lordship, around 11 months. He hasn't paid.
Give me a mask and come to work. Ano daw yung mask na come to work. Di ba? Ako sa mga wasa ko. Sabi na, bakuri mo ikaw.
20,000. 20,000. 20,000.
Di pas naman.
Oh,
Hindi.
that was 20,000.
Hmm?
And then that was 20,000. I hope you have been fair to the court in your submissions.
Well, I cannot say exactly whether
You cannot say exactly.
suppression of facts is there. Madam.
No, I hope you have been submitting correctly.
So that income, my lord, that is there in there. And certain liabilities are.
We'll see, we'll see. We'll see. Yes, Ms. Brown.
Yes, Your Lordship. So, my first contention is, Your Lordship, that the order was passed on 31st August 2023. And then they came before the court saying that they cannot be paying it after 13 months. They were suddenly aggrieved after 13 months. Secondly, Your Lordship, in that order, 31 August 2023, the court had considered by their own admission that he was earning 60,000 per month, which is why this interim maintenance of rupees
When is
6,000.
that 60,000 mentioned?
Your Lordship, in the in their own objection, Your Lordship, page 34 to 41.
Which para?
Yes, Your Lordship. Kindly allow me a moment. Your Lordship, para 11. And also, your lordship, in the order also it is reflected at page 48. Your lordship, the first para, the opposite party in his written statement has
Seven, page 48.
48.
Page 40.
And after considering their admission, your lordship, this interim maintenance was granted. And then next, your lordship, annexure 5, which is the petition that they're saying that they had furnished before the court and the court had not considered that. In regard to that, your lordship, they had sought for a direction that first the wife has to file her assets and liabilities, and thereafter they will be filing their affidavit. So, your lordship, but then it doesn't have any bearing because only the current state of affairs was supposed to be brought before the court. So, it had no bearing. So, which is why they had sought for that direction. However, the court had heard the matter on 31st August 2023, the day they had given that petition itself, only for interim maintenance. Also, your lordship, they have said that the wife, she is earning 30,000 per month. Your lordship, I would like to, if your lordship comes to page 243, your lordship. This is the letter of appointment of the wife. Your lordship got it? So your lordship, the remuneration part, paragraph 1. You along with your team will be paid a sum of rupees 30,000 based on the work assigned to your team per month by the organization. So basically it was not solely for her. And if your lordship turns to page 245, this is dated 2nd December 2024. Your lordship will again see the remuneration. You will be paid a sum of rupees 15,000 based on the work assigned to you per month by the organization. So basically, at this point of time, she's earning 15,000 rupees, your lordship. And your lordship, as of now, the wife, she's undergoing surgery as well. She's in Hyderabad.
So you're still working or what?
Yes, your lordship, still working, but then she's also having to look after her mother. She had taken her mother for treatment. However, even she has been diagnosed with gallbladder stones and
He has
some
also got
polyps.
to look after his mother.
Your lordship, but then he's an able-bodied man and then he left. And if your lordship sees the medical documents which were annexed,
He left. He left the job.
he left the job, your lordship. That is what their admission is. But also if your lordship sees in the affidavit of the assets and liabilities, the medical documents which have been annexed are of 2019 to 20. And this affidavit was filed in 2024. So there was nothing very recent to show that his mother was actually going through some distress or any disease or whatever, your lordship, illness.
But what is the income of the appellant now?
Your lordship, that I'm not aware because also, as has been informed by the wife, he does not even respond to her calls.
Anyway, this petition has been filed only in 25. And you are bound to pay the arrears. He has not paid.
There have been irregular payments and
Why should we entertain? We have not, we have failed to comply with the orders of the court, which have been passed 2 years back, 2.5 years back.
Well, there may be default for some few months, small amount, but
11 months.
I mean regularly we pay.
11 months, according to 11 months, a small amount, then you pay 6,000 a month with a small.
Last
amount.
month we have paid, man.
yes, your lordship, those are irregular payments because they do not pay it monthly.
Last month you paid. He says that you have not paid for.
That cannot be, man. That I have to ascertain that. I have to ascertain from the.
You do whatever. We don't find any reason to entertain.
Then the court decide again case, man. That the family court decide
Why should the family court decide?
because in the order is very cryptic, man.
Maybe very quickly in there if you have brought everything before us.
Because now we have.
You have said basically the 10,000 rupees
Yes.
is what you earn.
And another 10, well, in my statement, I've given 20,000.
Now you have read. That's why I asked you.
20,000.
You are making all submissions, wrong submissions.
10,000 as a rent, madam.
When you said that you had no other income, your only income was rent.
But that source has not been stated, but 10,000 from where is?
Maybe in your affidavit, but look at what you said in your written objection. And what was recorded
That
in
was
the
earlier in
court.
point of time, my lord, at that when I was walking. Man.
So,
That I've left the job, madam. They also admit, my lord. Yeah.
no, they don't admit. They are saying that it's your statement. It's your statement. For them, they do not know whether you are telling the truth or not. And that has been proved by what you just stated to us. That you're not very reliable
Because- Because my mother is bedridden, my lord. There was none to look after. So I'm taking care of her.
Very good.
Because-
You're very good. So what? You're not the only person in the whole wide world to look after
So there's none.
mother. There are some who look after their mother and father also.
And I'm suffering from some problems also. My depression is there, my lord.
Depression.
Depression, my lord.
Depression is all right.
Because of disturb family life, naturally he has got this.
Depression, nah. Actually, you're going through a separation period of separation. And then you have to hire a maid. Miss Brown, you did not want to work, no?
Your Lordship.
During the marriage.
Your Lordship, she had filed a petition for restitution of conjugal rights. It is them who had come with the divorce.
Really, because you did not want to work, he had to hire a maid to do all the things. But once you separate, you don't get that free maid service, no?
Yes.
Income from other sources. Rental income, 20. Okay, 20. But okay, 1,000 a month, how does? And your Assam type house is
It's a old house, my lord. It also requires renovation nowadays, my lord.
in Ulubari,
Uluveri, my lord.
prime area.
Maybe I'm here, but since it has to be reconstructed and then only I can give in on rent.
Leave it like that is better. We have that old world charm.
But my memory of life has been disturbed, so
Married family life.
that's why he's suffering from
What about her married life, family
both.
life?
Yeah.
Huh? Anyway, you all don't have a family. It's only you two. Then you want to come down from 6,000 to 4,000. You're not even paying that.
That I assure your lordship that I will pay the money. If your lordship will fix a date, I will show just let payment.
Because if he's not working, you have to work it. You have to pay. So the rule, I will give 20. Are you willing to come up a little bit instead of us passing an order rejecting your application?
I'm saying 4,000, my lord. That
Are you hanging on to 4,000?
of your lordship directs.
No, we're not. If we direct, we'll direct. Our direction will be. Our direction. We are pretty clear what direction we are going to
I
give.
understand.
So we have given you a hint.
I understand.
You don't want to take the hint.
5,000.
It's okay.
Make it 5,000, my lord.
You're willing to give 5,000.
No, Your Lordship. The reason being, Your Lordship, she had already communicated to me. Your Lordship, she's already undergoing distress, Your Lordship. She also has to go for treatment and she has got something called a polyp, Your Lordship, which may turn cancerous, which is why she has to go for surgery. I have the documents.
Madam, one thing.
Yes,
is
Your
that you're earning
Your Lordship, 15,000.
50,000.
Yes.
Now, he's saying that he's not earning.
Your Lordship, all the more reasons for him to be working.
That is all,
You're-
that's all right, but
yeah.
then it's not that everybody who wants to work gets a job.
Your Lordship, but then he deliberately had left his job. Now for reasons best known to him. And as of today, we do not even know.
Yeah.
We do not even know, Your
No,
Lordship.
no, we do not know. See, there can be a myriad of reasons. You might have your reasons for saying that he left his job to deprive you of the maintenance amount. His story is that he had to give all his attention to his mother for maybe whatever reasons. I don't know what the reasons. Because, but I know, we see, because here, the thing is that what he's saying might be true to a certain extent. That he is suffering from something, the mother is suffering from, and that he's really not working.
So, Your Lordship, the wife is also on the same footing. But then she's working so that because she can take care of her mother.
You cannot force someone to work this way.
Yes, Your Lordship, but
See-
then this shouldn't be a reason that, one gets married and then leaves the wife high and dry, saying that I will not work and I cannot pay you. Your Lordship, then this is also not fair.
No, what we can do is, in the event that you find out that he is back to work, then you can again ask.
Your Lordship, at this point, I'll pray that Your Lordship, this order may not be interfered with, Lordship.
Over here. I'm not going. They don't know. After. Is that true?
Okay, right. I had Mr. P. Kataki, Learned Counsel for the petition, and the Legal Aid Counsel, Ms. M. K. Brown. This application under section 528 BNSS, 2020. Read with section 19 bracket 4 of the Family Courts Act 1984. Has been filed by the appellant husband against the impugned order dated 31/8/2023. And order dated 3/5/2025 passed by the learned Principal Judge, Family Court number 3, Kamrup at Guwahati in FC bracket criminal number 331/2020. By the impugned order dated 31/8/2020. The learned family court has granted interim maintenance amount of rupees 6,000 per month to the respondent. And the same had been put to challenge. No, full stop, no. The same, the said impugned order dated 31/8/2023 had been put to challenge after 13 months. And the same was dismissed by the impugned order dated 3/5/2020. Next slide. The appellant's counsel submit, no, the petitioner's counsel submit, huh? Petitioner or appellant?
The petitioner.
The petitioner's
Criminal division.
submit that the petitioner does not have any job. Does not have any job at present. And his only income is rupees
20,000.
20,000. We should have given you a hint. 20,000. Comma 10,000 rupees being rent derived from his 1 BHK flat located at Azara, Guwahati. And the remaining 10,000 rupees from other sources.
Other source.
What other sources? From other sources. What other sources?
There,
Digging a hole. Huh? You've got no job. So what other sources can it be?
other sources maybe more for FDRs and all that.
Huh?
Fixed deposits are there, man. Interest amount is there. That has been stated, man.
Oh, you've got fixed deposit.
Yes, hello. Interest is getting, man.
Have you mentioned those fixed deposits
That has,
particulars in the thing? In your affidavit?
affidavit of bank statement is there, my lord.
No, fixed deposit. Bank statement will not show your fixed deposit, Mr. Council. Even I have a fixed deposit in my bank, in my statement of account. My fixed deposits are not shown.
Because here say in the column number 8, my lord, interest from other sources, my lord, the rental income 10,000, other sources, my lord. This is shares, dividends, capital gains, FDRs, but not specific activity.
Oh, you've got shares also.
Not specific has not been given, my lord. Just a broad line, my lord. That column, my lord. Anyway, that basically from the share interest, maybe for fixed deposit from the mutual fund or the venture, or anyway, we don't know, my lord.
You don't know.
No, be specific, yeah, particulars are not given, my lord. So difficult to say.
But you're the husband, you're supposed to know.
But details has not been given. How can I say? The details have been given, matter of they've been given.
Right. He submits that in view of the income of the petitioner being only rupees 20,000 per month, it is difficult for the petitioner to pay rupees 4,000, 6,000 per month to the respondent wife.
And-
That is your only case. He also submits.
And moreover, that my mother is suffering from a severe hip bone fracture.
Hip bone fracture.
In
So
2019, Your Lordship.
fracture, so he
And
has
we do
to
not know as of today what
She
the
is very
status
driven.
is.
How old is she?
see the age has not been given, but I can from the prescription it can be what is it?
76
76.
Now 76. At that time.
now.
Now. And the incident occurred in
In 2019.
19. That means around 59 years. One thing is that, madam, hip bone fracture, when the elderly get it, very difficult to repair.
Your Lordship, which is why I'm saying even the wife's mother is also undergoing treatment. She's also undergoing surgery. She's in Hyderabad right now, Your Lordship.
He doesn't have a bounden duty to support your mother.
I'm not on that, Your Lordship. Which is why I'm saying the wife,
For you
she
and
being a woman, if she can be working and taking care of her responsibilities, why can't this husband do it?
because he's a good for nothing, what to do?
And make that out.
You can't force them to work if they don't want to work. So what do I say? You also submit that the petitioner is living in his mother's house, which is a Assam type house located in Ulubari, Guwahati. As his mother has got a hip bone fracture. The petitioner has been looking after her since 2019. When did you leave your job?
2023.
He also where does it say that?
No, Your Lordship, I just, because he said that after filing the written
No,
appointment.
don't.
Yes, Your Lordship.
Don't, it's not your job to do that.
Yes, Your Lordship. No, I just made the statement.
Your job is to find hole.
Yes, Your Lordship. No, because only the petition says that. Petition number
Let
821.
him say it, no?
Before filing of these assets and liabilities, That,
Before filing, you,
well, this exact date has not been given, my lord.
yeah, I don't know, the more you're speaking, the bigger your hole is becoming and deeper.
Because there is a
At
column,
the
my
end,
lord.
at the end, the hole might swallow you up.
Understand, my lord. Because there was a column, my lord. If you engage in a private sector, kindly stating the designated gross monthly income. He says that not available. So at the time of filing, he was not in job, my lord. That prior to filing, he has resigned. That exact date I cannot.
At the time of filing,
He was not.
he wasn't having a job.
Job, my lord.
When did you file?
That was filed on 5th September 2024.
5th September 24.
24.
So you said that before filing,
Most probably, he had put it-
before filing, he did not have a job.
maybe in 23 he has resigned. Man. That we cannot say. My lord, we don't have the resignation letter. Also, nothing is there.
Wait. Before filing, he did not have a job. And the impugned order is of 2023.
No, 23, 20. After there is 3524.
Huh?
3524.
What?
Impugn order.
No, the first impugned order is 31/8.
The 31 weight was
Now no, I think you're making up, you're starting to make up. That's what we're saying. You're starting to dig a hole. It's becoming bigger and bigger the more you speak.
31 mail was before filing of assets and liabilities.
So when did you file your assets and liabilities?
After the passing of the order, that is on. My assets and liabilities 5th September 2024.
5th September 24.
And thereafter, the 3524 order was passed.
3525. You see, it cannot be 3524 order was passed.
Last one.
And the assets of liability was filed in?
Filing 5th September, man.
Huh? So which comes first, 5th September or
No?
35?
Impugn order. The Lordship may kindly say the impugn order, man.
May.
3525, sorry, 3525.
3525. Say that,
3525.
but then that doesn't take away the fact that at the time of filing your assets and liabilities, the earlier order had already been there.
Earlier order was there. That is, the earlier order was there. Man. So after filing of the asset liability, we made an application before the court. Since assets and liabilities has been already filed, and in view of the decision of House of Apex Court in hand, so that assets and liability may be taken into consideration, and the amount may be.
What have I said? Nineteen. He submits that the petitioner is willing to pay rupees 5,000 per month as interim maintenance. As on. Next, Ms. M.K. Brown, the learned legal aid counsel for the respondent wife. On the other hand, submits that the respondent was employed with a private company at a salary of rupees 15,000 per and not 30,000 as can be made out from the
Written of the truth.
from the letter of appointment dated 1/4/23 issued by, and 1/4/23 and 23 and 2/12/24 issued by the issued by what agency is it?
My lord, I'm sorry to,
Bimal Auto Agency.
Bimal Auto Agency.
But in their
can you
affidavit, yes, there are 30,000.
Oh,
See, my
respondent. Page number 63, my lord.
That is. He has clarified that
Yes, madam.
It's here at page 243.
Yes, madam.
Anyway,
Anyway, madam.
we will see. If we'll take that, okay, we'll take that and we'll take a 60,000 also. Next. He submits that the respondent has to look after her mother, who is undergoing surgery.
Yes, Your Lordship. Your Lordship, treatment may be written because I'm not very
Undergoing surgery and treatment.
treatment.
He submits that the petitioner is earning rupees 60,000 per month as per the written objection filed by the petitioner before the learned family. And as such, the impugned order should not be interfered. That's all.
Yes, Your Lordship.
We have heard the counsel for the party. Para 11 of the written objection submitted by the appellant, by the petitioner in FC criminal case number 331 of 2020 states that the petitioner works at Reliance Jio Infocom and draws a monthly salary of rupees 60,000. The same is also reflected in the impugned order dated 31/8/2023 passed by the learned family court, where it is recorded that the appellant had claimed his monthly salary to be rupees 60,000. With regard to whether the respondent wife was earning rupees 15,000 per month, the letter of appointment dated 1/4/2023 issued by Bimal Auto Agency states that, shows that the respondent and her team were to be paid rupees 30,000 per month based on the work assigned to the team. The subsequent letter dated 2/12/24 issued to the respondent wife by Bimal Auto Agency says that the appellant petitioner would be paid rupees 15,000 per month. As such, it is quite apparent that the appellant, that the respondent has that the respondent's salary is rupees 15,000. Next part. The question to be decided is whether. No, beside that. Before that. The affidavit showing the details and assets, showing the details of assets and liabilities of the appellant, which has been submitted in the learned, before the learned family court, shows that the appellant has stated that his income is rupees, monthly income is rupees 20,000. Rupees 10,000 is rental income and rupees 10,000 is from other sources. On considering all the aspects of the case, we are of the view that the interim maintenance amount may be reduced to rupees 5,000 per month, as prayed for by the learned counsel for the petition. However, as we have been informed that the petitioner has not paid 11 months of area interim maintenance in terms of the impugned order dated 31/8/2020. We direct the appellant, the petitioner. No, don't say we direct. The petitioner directed to, the petitioner shall pay the area amount of interim maintenance at the rate of 6,000 per month within a period of 1 month from today. From today, failing which interest at the rate of 8% per annum will be payable on the entire 11-month arrear amount till final payment of the entire amount.
One thing, probably the area amount is not 11 months, he has paid in between. So your lordship may mention the area amount, only area amount.
Okay, 11, there's 56,000. 11 months, 56,000.
Yes, madam, but
Exact, may not be 11 months, maybe
11 months,
less.
because he has made payment on the last.
You give us how many months by 2 PM? We are here. Now we'll put it. How many months arrear?
Whatever area amount is there, we'll pay in 1 month.
Can you give us the months?
Your Lordship, I can try at 2 PM.
Whatever area you will
Whatever
pay.
area is there, we'll pay at the.
No, if we say that, you all are going to say no, 10 months or 7 months, that issue will, so 11 months, okay, make it 66,000. Arrear, 11 months, 66,000.
Let the trial court,
That's why you take it back, otherwise you come up with a figure at 2.
yes.
Otherwise we'll
That
dismiss,
I can.
easier for us to dismiss
Yes,
the
yes.
entire thing.
No, my lord,
You bring it by 2 or we'll
By
dismiss
2,
your repetition.
by 2.
Cannot have your cake and eat it too.
Find out.
Mrs. Brown, you also have to do.
Yes, Your Lordship.
Both of you at 2 o'clock, you'll come.
My lord.
Everything is the same. Because the same amount will be paid. This is one thing you think without going into the merits of merits and the merits of the case and without making any observation as to whether the submissions of the council are true or not with regard to their income and employment status. Ah, yes.
Lordship, paper book has been prepared, Lordship.
Item,
Item 3, Lordship. There is an IA pending, Lordship, regarding 430 application.
yeah, you can see. There are three. That,
Lordship, in the paper book, Lordship, FIR is on page 3, Lordship.
are you ready, mister?
My lord, we have filed the objection. That copy was not with me. I'm just taking from him, my lord. Well, let him. I will assist my lord.
Yes.
Lordship, in the paper book, page number 3 is the FIR, Lordship.
Yes.
I have the honor to inform you that on 1/10/2018 at around 5:45 PM, I have telephonic conversation has received from my wife that one quarrel has started our rented house at Salakati Bazaar among our tenant, Sahabuddin Alam, then Sikandar Kumar, and next,
Santosh Kumar.
yes, Santosh Kumar. I have immediately rushed at the place of occurrence and found dead body of Mohammad Shakil, 42 years, of Bihar inside the room campus. I have immediately informed the matter to police. I suspected that the following persons have murdered him. This is the FIR, Lordship. All the 4 persons, Lordship, were tenants. They were working in NTPC, Lordship. They are daily wage laborers, Lordship. They were working there. They were, Lordship, convicted under section
30234.
34, Lordship. They were convicted, Lordship. Now, Lordship, in this case, Lordship, the conviction has been based upon, Lordship, circumstantial evidence, which is crucial evidence of PW 14, Lordship. Also, Lordship, another thing, also in the last scene theory, Lordship. Now, starting from, Lordship, PW 1, Lordship, which is on page number 7, Lordship. All the informants have not seen anything or they have not heard anything, Lordship. Starting from number 1, Lordship. Lordship, if we go directly to PW 14 and the IOS evidence, Lordship, it would be more helpful.
You see, for 14,
Yes, PW 14, which is on page number 21, Lordship.
yes,
Lordship, he is, PW 14 is one of the neighbors in that rented house, Lordship.
yes.
Lordship, in his chief, Lordship, he has stated, I know the informant and all the 3 accused persons. The incident happened in the year 2018. At that time, I was staying in the rented house of the informant as a tenant. I was working under NTPC. All the 3 accused persons were also working under NTPC and they had been staying in the rented house of the informant. Deceased was also a tenant of informant. On the date of occurrence at about 5 PM, I returned to my rented room after my duty. I saw a quarrel between all the 3 accused persons and deceased. I went to Tubewell to freshen up and after returning to my room, I saw the deceased lying on the ground near the door inside the rented room. Then I immediately informed the informant, who is our landlord, about the incident. He informed the police. Later on, police came and took the dead body of the deceased. Police also apprehended all the 3 accused persons and took them to police station. Now, page number 22 is his cross, Lordship.
Yes,
The police recorded my statement, then a suggestion, Lordship. It is not a fact that I did not state before the investigation officer that I saw the quarrel
between all the three accused persons and deceased. Now, contradiction, Lordship. I did not see as to how deceased died. There was no enmity between the accused persons and the deceased. Now, important line is, I had not seen any incident of dispute or quarrel between the accused persons and the deceased. Since long myself, the accused persons and the deceased have been staying in the rented house of the informant. I did not know the cause of death of the deceased. The deceased had friendship with the accused person. They used to roam around together, had their meal together.
So, you see, these persons were with the deceased at that time.
These persons were at the deceased at that point of time. They shared tenancy, Lordship.
So, what was, so you see, now you come to PW one,
Lordship.
1 and 2.
1 and 2. Yes, please read.
The informant is my maternal uncle. I know the accused persons. The incident occurred at our residence. We have tenants in our house. The accused person are our tenants. At about 5:30 p.m., my elder brother called me to the room of the accused person where I saw the dead body and blood was coming out from the stomach region.
So blood was coming out from the stomach region mean it was still fresh.
Yes.
There, read.
And the accused persons wanted to flee.
Ah,
But Lordship, that has been negated by the IO in his cross-examination.
there is,
Yes, Lordship. But myself, along with Rithun, apprehended the accused persons. Thereafter, police was informed and they had come to the place of occurrence and took the
now
dead
come to
body.
PW two.
Yes, Lordship. The informant is known to me. I also know the accused person. The incident occurred about 4 or 5 months back at about 5 to 5:30 p.m. Rithun called me to his residence. I saw the dead body of the person on floor of a room and blood spilled around them. I saw the accused person standing outside the room and the accused person wanted to flee from the area, but we apprehended them and informed police. Police came to the place of occurrence and took the dead body and the accused person. Now, in his cross, he also states that he does not live in the house where the occurrence took place.
Kindly peruse PW 5, the cross portion. The knife was seized outside the room rented out to the accused person.
At the time of occurrence, I was not present at the place of occurrence. I do not know how the deceased died. I have 4 rooms rented to 4 groups of tenants. One of the rooms were under occupation of the accused persons and the deceased. The room adjacent to the room rented out to the accused persons were occupied by a husband and wife. All 4 rooms are occupied by tenants. My statement has not been recorded by police. The knife was seized outside of the room rented out to the accused person. The body of the deceased was inside the room. I do not know whether the knife had stains or not. I had informed the police over telephone before lodging written FIR. The written FIR was lodged on the next day. I signed the seizure on the day of occurrence. At that time, I had not lodged any written FIR. I do not know how the deceased died.
Yes.
Lordship, thereafter, Lordship, the IO in this case, Lordship, PW 17, Lordship. That is on page 28.
There.
In his chief lordship, he has stated on 2/10/2018, I was posted as in charge at Salakati OP outpost under Kokrajhar PS. On that day, I received an FIR lodged by Mr. Brahma. On receiving the FIR, I forwarded the same to officer in charge of Kokrajhar PS, who registered Kokrajhar PS case and entrusted me to investigate the case. Accordingly, I visited the place of occurrence, drew up the sketch map of the place of occurrence, and recorded statements of all the witnesses. Exhibit is the sketch map. Exhibit P7 is my signature. At the place of occurrence, I found the dead body of the deceased in his rented room lying on the floor. I sent the dead body to the hospital for post-mortem examination. I also seized one knife from possession of the accused person. I apprehended accused Sahabuddin, Sikandar, and Santosh Kumar, who were found at the place of occurrence, and took them to police station. After interrogation, the accused persons were formally arrested. The accused persons were produced before the learned magistrate on my prayer. Learned magistrate allowed police remand of accused persons for 2 days. After expiry of the remand period, accused persons were produced before the learned magistrate, who forwarded them to judicial custody. Meanwhile, I had been transferred, for which I was handed over the case diary to officer in charge of Kokrajhar PS. Now in page number 29, which is the cross, I recorded statement of witness whose names were cited in the charge sheet. FIR was lodged on 2/10/2018, which is a day later after the incident. I recorded statement of witnesses, namely Vijit Bosumatari and Rupam Brahma on 2/10/2018. On 1/10/2018, I recorded statement of witnesses, namely Fiza Khatun, Mohammad Javir, Ismail Mia, Nasrul Khatun, Urmila Devi, Kiran Devi, Mohammad Shehzad Ali, Abrul Mia, Rithun Bosumatari, and Birdao Brahma. I have recorded statements of the informant on 5/10/2018, but his statement is not available in the case diary. GD entry number and the police case number were mentioned in the case diary. Therefore, I did not mention the GD entry number of the police case number again in the sheets where I recorded the statement of the witnesses. In the GD entry, it has been stated that all three accused persons were apprehended by villagers on suspicion of murder. The inquest of dead body was done on 2/10/2018 at about 1 p.m. Till then, no FIR was lodged. Now, important part is starts from here, Lordship. On 1/10/2018, I seized the knife in the seizure list. I have mentioned the police case number. I mentioned the police case number in the seizure list subsequently at the time of producing the seizure list before the learned magistrate. On 15/10/2018, the seizure list was seen by the learned magistrate. Till then, the GD entry number or police case number was not mentioned in the seizure list. In the seizure list, I did not specifically mention the name of the accused persons from whom I seized the knife. Though I stated in the seizure list that I seized the knife as shown by the accused, but I did not specifically mention the name of any of the accused persons. In the seizure list, I also did not mention the place from where the knife was recovered and seized. I did not obtain fingerprint of the accused persons for matching the same with the fingerprint available in the seized knife by the expert. I did not send the knife to FSL to ascertain that it was the weapon of offense. Also, I did not record statement of wife of the informant. On 1/10/2018, I prepared the sketch map. I mentioned that GD entry number in the sketch map. The sketch map did not have time of preparation. I prepared the sketch map at 6:50 p.m. This was a relevant entry in this regard in the case diary. I did not record statements of Kartik Nagar.
Sir, why should we now disbelieve the evidence of PW 1 and 2?
Lordship,
And 14.
and lastly, Lordship, PW2, Birda Brahma did not state before me that the accused wanted to flee from the place of occurrence.
Huh? Did not want to.
Flee, Lordship.
But then was there any question put to PW 2 that he did not state that fact to the police?
Lordship, his statement, Lordship, he contradicts himself, Lordship. When the IO said,
How do you, what does the Supreme Court say?
Lordship, generally, Lordship, generally what Supreme Court states in a matter when someone is fleeing, Lordship, there is a chance that when someone sees a dead body or someone, he may run. That is not a, Lordship, a sign of someone who is guilty, Lordship. There are certain of judgments regarding that, Lordship. Merely trying to flee from some place cannot be a sign of, Lordship, someone being guilty.
How do you demolish the evidence of a witness?
Lordship, PW2 already negated by the fact by the IO himself that he contradicts himself.
You have got to put that question to the witness itself also.
Yes, Lordship.
You have got to put that question to the witness also.
Yes.
You did not state this to the police.
Yes, Lord.
That has not been done.
That was not put into cross.
Then
But
so there are three aspects. Well, I mean, the question has to be put to the witness, to the IO, and then on.
yes, Lord.
Can we say that the procedure laid down by the Supreme Court has been followed? Then if it's not done, then what do we do? We say that it's been followed.
But Lordship, also another thing that Lordship, that the fact that merely fleeing from the place of occurrence cannot be a sign of guilt, Lordship.
But then doesn't it give, fill in the blanks? It'll be a part of the chain of the circumstantial evidence.
Lordship, the murder weapon will also be a chain of,
Huh?
The murder weapon would
It was
also have been a
found, the
check.
murder weapon was found.
Yes, found, but it was not sent for any,
Correct, that was not done.
yes. That is also procedural lordship. If it is recovered from there, no FSL
What
was
were
done.
you doing in that, you all were all, there were 4 rooms in that
Lordship, we were staying in the same room,
same room. You all were staying in the same room.
same room.
So if you all were staying in the same room, how did he die? Did he kill himself?
Lordship,
I-
he had a, Lordship, one of the witnesses.
Their conduct and my lord, if
That's
it-
what, you see, if they were in the
That-
same room, they
Same.
were all together, blood was pouring out from his belly.
and my lord,
Then you would have known how that blood was coming out.
Lordship,
Knife was there also. But you all have basically said that I did not kill, I did not kill, I did not.
Lordship,
But then the
PW9.
question that everybody wants to know, the whole country wants to know, like, is how did that blood come out from there? What did you see?
Lordship,
You're basically turning a Nelson's eye.
Lordship,
It's like
PW9.
an ostrich. You know what an ostrich does?
Yes, Lord.
When it's in danger, it buries its
But-
head
Yes,
into another ground, doesn't see anything. So he thinks it's safe.
yes, Lord.
Like that. You were there. There are 4 of us. We see one person with who's our roommate. Blood is coming out.
No.
And we don't know. We say that we didn't kill him. I didn't kill him. I didn't kill him. We deny everything. Is it expected of a normal person,
Also, Lordship, one thing, Lordship.
an innocent person to say that?
Also, Lordship, there is only one stab injury.
One is enough to kill, no?
Yes,
How many
one
do you
is
want?
enough, Lordship, but
One
when
bullet is enough.
3 persons,
It-
Lordship,
you
are
don't need
there.
you don't need a anti-aircraft gun to shoot. Like
Lordship,
has been done in apparently done in I don't know North Korea. No, his wife's uncle. I don't know, his uncle. That's the rumor. I don't know. The problem is that you pay live stream. That's the problem. So, that's what I read somewhere. But what I'm trying to say is that one stab wound is enough. One bullet is enough. Depends
Yes.
upon whether it is on the vital part of
Vital
the body or not.
Lordship, a single stab wound, 3 persons, Lordship. Also, the fact that PW9,
How do you know? One person to hold one hand, one person to hold another hand.
where there are no injury marks other than the single stab wound. Lordship.
Tell me something. If there are 4 persons or 3 persons, one holding one of your handy, one with a knife, supposing a person puts it through your heart, the knife. Isn't it enough? One stab wound.
Lordship, it is enough, but there will be a sign of struggle.
No, doesn't have to be. Where is the struggle?
Because
Yes, struggle.
someone is trying to attack or trying to stab, he will struggle, Lordship. He will fight back.
But then you see, when there are 3 against 1, there's no chance for a struggle.
Also, the fact that, Lordship, PW14 himself stated, Lordship,
Unless
contradicted
they-
his own
un-
statement.
Unless you are having very skinny guys, 3 small, 5 foot, not even 5 foot guys, skinny, no strength, no muscles, trying to hold on to Arnold Schwarzenegger, Terminator. That's a different thing.
One thing is correct, Lordship, they are skinny guys, Lordship. They are laborers.
But tough. Tough. Laborers are tough.
Yes,
Think that
that is
they are-
true.
They're all, they don't have big muscles, but they are tough. Very, they
Lordship,
can lift off.
yes. One thing, Lordship, PW9
No case,
states,
Mr. Kamalkar, no. It's not believable.
Lordship,
Will you believe? Supposing you are the roommate.
Lordship,
You were there. Everything happened before you. Or even if it didn't happen before you, you should have said what had happened.
it
But-
was their duty, my lord.
Huh?
Actually, it was their duty. Their roommates.
May not be saying that I don't like this fellow.
Yeah.
We don't know, but you should have said it was under 106. You were the only person who could have thrown light on
Lordship.
what had happened.
The only thing linking them to that thing is PW 14, Lordship. He himself has contradicted the whole fact that there was a quarrel in between.
We don't.
PW 14, Lordship, in his.
There can be many a slip between the cup and the lip.
But
The only
Lordship,
problem
the
is out.
material
You
aspect,
had a
Lordship.
PW1 has said that is there.
PW 1 and PW 2, PW.
Forget to PW2. PW1 is enough.
Yes, Lord. But
PW1
PW
is
14,
enough.
Lordship,
Huh?
the main witness, Lordship, linking them to the whole.
No one has seen the incident.
Yes, Lordship. That's
No one has seen the incident. Only you saw the incident. The
Yes.
problem is you're keeping quiet.
yes.
And like you said, you are a roommate in one room. You all are all living in one room.
Shared tenancy, Lordship. Yes.
Mr. Das, your silence is, we can draw adverse inference to, on that. Because
Yes.
it was your duty to explain.
But one thing also, Lordship, there is that 106 will come when the prosecution is able to fully prove the chain of circumstance, in which case they have not been proven here. Lord.
The circumstantial evidence is there. Your entire action, keeping quiet,
Keeping quiet,
the knife being there amongst y'all.
The 106 burden
The
lies on
blood. You see, if that body had died 6 hours ago or something, and the blood had all solidified, okay. But the blood was oozing out,
fresh.
was coming out. It's a fresh wound.
flesh.
Fresh wound. It's a fresh wound. It's not a wound that happened 2 days ago or 1 day ago or 6 hours ago. It's a fresh wound. And you saw a nice, see the blood coming out. That's what you said most probably to yourself. Didn't do anything. Didn't even try to take him to hospital or anything.
Lordship, sometimes people, when they see,
They're
they get
shocked.
stunned also.
Yes, sir. But then at the time of the evidence, you should have said something. That was
That-
a
that is
third
the-
Mr.
is a PK Das, Lordship.
Das, learned counsel for the applicants. And Mr. R.R. Kaushik, learned APP. This is an application under section 430. BNSS for suspending the sentence awarded to the applicant in relation to the impugned judgment dated 30/4/2025, passed by the Session Judge Kokaja in Sessions Case number T1/06/2019, by which the appellants have been convicted under section 302/34 IP. The applicant's counsel submits that there were no eyewitnesses to the crime and in terms of the evidence of PW 14, PW 14 had denied had stated that he did not know the cause of death of the deceased. Anything else?
Lordship, PW 14 and also Lordship.
First off, further, he did not see the quarrel
No,
between the accused person. And next part. He accordingly submits that when there is a doubt, when there is nothing to show. And further. PW2 had, no, further, the case investigating officer, bracket PW 17,
17. Lordship.
in his evidence had admitted the fact that PW2 did not tell him that the applicants wanted to flee the place of occurrence. Correct?
Correctly.
He accordingly submit that the application for suspension of sentence should be allowed as the prosecution has failed to prove the case of murder against the applicant. Mr. R.R. Kaushik, Leonard APP. On the other hand, submit that the evidence of PW 1 and 2 clearly prove that. No, clearly shows that the circumstantial evidence and the fact that the applicants wanted to flee the place of occurrence prove the guilt of the act. Further, though the applicants were roommates of the deceased and were present at the time blood was oozing out from the stomach of the deceased, which showed that the wound was a fresh wound. The applicants have not thrown any light as to how the deceased had been stabbed or had been inflicted with the injury. Established that when there is no attempt made by the applicant in their examination under section 313 CRP to explain the wound that had been inflicted upon the deceased, the same was an added link in the chain of circumstances pointing to the guilt of the applicants in killing the deceased. Next part. We have heard the non-conflict protocol. We have also seen the evidence of the prosecuted witness. On considering the submissions of the counsel for the parties and the fact that no explanation has been made by the applicant as to how the deceased was inflicted with the wound on his body, which ultimately led to his death. We are of the prima facie view that the sentence imposed upon the applicant should not be suspended at this stage. Accordingly, the application is dismissed. We won't make any observation. I is accordingly dismissed.
You see, the hearing date is
In the main case, you're right. As the counsels for the parties submit that they have been furnished copies of the paper book.
Yes.
Leaves the matter on. Where do you want?
Lordship, in the month of March,
Give a date when.
seven, eight, seven. Obliged. Victor.
17th will be problem. I think 17th we've got a lot of fixed matters.
Yes, only yesterday also.
17th and 19th, so we've got a lot of fixed.
On 20 or
No, 19, 20 also we have got one matter.
Obliged.
Mediation.
Mediation failed, Lordship. Counsel to the other side. Last question also.
Page 1 is the FIR. The Lordship takes up column number 3. Occurrence of offense date is 18/5/2007. Page 1 of the paper book.
Yes.
Exhibit 4, this is the FIR. My lord, occurrence of offense, item 3, 3B, date 18/5/2007. C, information received 30/5/2007. There's a delay of 12 days in lodging the FIR. Now, if your lordship comes to page 4, this is the FIR. Informant is the husband of the deceased. Page 4 is the FIR. Sir, humble submission is that around 10 o'clock on 18/5/2007, the said accused person hacked my wife Hassan Banu with a sharp dowel from behind, as a result of which she sustained grievous injury. She was initially treated in Hajo Primary Healthcare Center and thereafter she was referred to GMCH for better treatment. Yesterday, that is on 29/5/2007, the injured woman was released from GMCH and was allowed to come home. But around 4 a.m. on 30/5/2007, that is today, the said injured woman breathed her last. I therefore pray to you to take necessary action regarding this incident and oblige. First, she was treated in Hajo Primary Center. Thereafter, she was sent to GMCH. The charges were framed under 302. And therefore, my lord, the evidence starts at page 8 of PW1.
The thing is that because he came home on 29.
Now we take page 8, PW1. Where is the informant?
Yes.
The accused of this case, namely Mirza Begum, is my daughter-in-law. This is Hassan Banu, was my wife. About 6-7 years ago, Hassan Banu died. Around 9 a.m. on the day of the incident, I was milking the cow. My deceased wife, Hassan Banu, was holding the calf near me. At that time, my daughter-in-law, Mirza Begum, came taking a dowel in her hand and hacked on the head of my wife, Hassan Banu. Then I left the task of milking the cow and held my wife's head. After hacking my wife with the dowel, I saw Mirza running away from the place of occurrence. Thereafter, my neighbor, Khateja, she is PW2, and I lifted my wife to a sumo vehicle and took her to the medical. Since she was referred from Hajo Medical to Guwahati Medical, I took her there. My wife was treated in Guwahati Medical for 6-7 days. Thereafter, she recovered to some extent. I took her to the house from Guwahati Medical. After staying in the house for 2 days, Hassan Banu died in the house itself. Thereafter, I lodged an Ezahar at Hajo PS in connection with this incident. Exhibit 1 is the Ezahar lodge. Exhibit 1-1 is my signature. After lodging the Ezahar, police held inquest on the dead body of my wife. I put my signature in the inquest report as a witness. Exhibit 2 is the inquest. 2-1 is my signature. Cross-examination. After the incident, the police questioned me. I did not state before the police that blood was coming out from the injury of my wife. I did not state before the police that Khateja and I lifted my wife to the sumo vehicle and had taken her to the medical. My daughter-in-law, Mirza, and my son live together. Mirza does not have mental illness. I cannot say as to why my daughter-in-law had hacked my wife. On the day of incident, I did not lodge the FIR. I lodged it after the death of my wife. It is not a fact that Mirza Begum was not mentally sound and that if she did something, anything under mentally unstable condition, it was not a conscious act on her part. It is not a fact that my daughter-in-law Mirza lost her mental stability at the time of incident and that she was not aware of what she had done. Now, my lord, PW2 at page 11. I know the accused of this case, Mirza Begum. Informant Samir Ali is the elder brother of my husband. Deceased Hassan Banu was the wife of Samir Ali and she was my sister-in-law. Mirza Begum is the daughter-in-law of Hassan Banu and the informant. The incident took place 5-6 years back around 10 a.m. on the date of incident. I was in my house. The house of the informant is situated near my house. There is another house in between our houses. At the time of the incident, I was in my house and hearing hue and cry in the house of the informant, I went there and saw that my sister-in-law Hassan Banu was lying there with injury on her head. My brother-in-law Samir Ali said that Mirza had hacked my sister-in-law Hassan Banu, so she is not an eyewitness. I did not see Mirza there. Later, we wrapped her head with a cloth and the informant Samir Ali and I took her to Hajo Medical by a vehicle. The doctor put stitches to her injury and from there she was taken to GMCH and she was given treatment there.
After staying few days in Guwahati Medical, Hassan Banu was taken home. Hassan Banu died after staying at home for few days. Later, my brother-in-law Samir Ali lodged an Azahar at Hajo PS in connection with the incident. Police came and questioned me about the occurrence. I have forgotten as to whether the police questioned me in connection with the occurrence or not. Mirza Begum got married a long time ago and might be 30-40 years that she got married. I know Mirza Begum since then. It is not a fact that police questioned me. It is not a fact that I did not state before the police that Samir Ali told me that accused Mirza Begum had hacked Hassan Banu. I do not know if Mirza was mentally unsound from before. There is a house in between the houses of the informant and me. It is not a fact. Samir Ali did not tell us that Mirza has hacked Hassan Banu. At PW3, he is the doctor who had conducted the postmortem. On 30th May 2007, I was at GMCH as professor and head forensic medicines. And on that day, I have performed postmortem examination on the body of Hassan Banu on being identified by Constable so-and-so and Moinur Ali, who is the paternal nephew of the deceased. The postmortem was done with reference to Hajo PS case number 103 of 2007 under 302 IPC. My lord will see injury number 1, an old stitch wound over the right temporoperito-occipital region, 18 centimeter in length. Old stitch wound. Thereafter, he says brain
Old,
is
how old?
but it does no
2 hours old? How
no
old?
mention.
So it could be 2 hours old, could be
Could be
20
2
hours
hours
old, could be,
Could be 2 hours old.
could be 200 hours old.
Could be. There's no mention. My lord will see the opinion. In my opinion, death was due to coma as a result of injuries on the head, where antemortem being caused by heavy sharp cutting weapon and were homicidal in nature. Time since death is 6 to 12 hours. Exhibit 3 is the postmortem report. My lord, the cross-examination just 1. Exhibit 3 is the carbon copy, including my signatures. I found only 1 injury. The original postmortem report has not yet been not in the file. I have checked it. It is a carbon copy, but below his signature, a seal is there of the doctor. But after the seal, generally if it's a Xerox copy or carbon copy, you put a seal and you again sign it. It's like certifying. I'm certifying that this was created by me. There, this fresh signature is not there. Primary signature is not there. So this postmortem
So
report,
what is the consequence of that?
my lord, this is not a secondary evidence you cannot give. I've come up with a judgment. You cannot, it's postmortem report in that same case, a carbon copy was exhibited.
Is it fatal?
My lord, thing is, here there are 2 aspects. First aspect is she was treated in Hajo first, whatever treatment was given. Secondly, she was treated in GMCH. This treatment thing, whatever was done, whatever was not done, why she was discharged, nothing on record. In that context, when the primary evidence of postmortem report is not there, because my lord, if somebody goes to government medical institutions with injuries, at least they have to make a GD entry. They ought to make a GD, otherwise how you had sustained it. And suppose I was cutting wood, I myself got some injury, then I understand. I'll have to say that to the doctor that I was cutting wood, I got injury. Here, the allegation is I'm trying to kill my mother-in-law. These 2 persons, PW1 and 2, who had supposedly taken her to Hajo Medical, then to GMCH, they don't say that we have informed the doctors. Had they informed the doctors, definitely they would have made a GD entry. That's why my lord, the Bhanagar police station is inside GMCH. They have an outpost there. So whether she was even taken to GMCH or whether she was even taken to Hajo Primary Health Center, nothing on record. So whether she had sustained that injury on 18/5, whether that incident has occurred on 18/5, where is the evidence? If it
Yes, this PW1 has seen it.
exactly, my lord, that's what I'm saying. If I have injured you, there has to be the evidence of the injury that on 18/5 this has happened. He has filed the FIR after 12 days. Why? My lord, it's not necessary that only he has to file the FIR. Anybody could have filed. This second lady, Khateja, I understand. A person, your wife is severely injured. You're taking her around to the hospitals. I completely understand. But after she was taken to GMCH, why did not this cut
See,
that
they
off?
wanted to keep everything in the family. Daughter-in-law killing hacking the mother-in-law.
If that is the case,
Might not have been a very serious injury that.
I understand, my lord. If that is the case, she was released from hospital. She had died at home. Just bury her. If they wanted to keep it silent. She was released from hospital.
Why didn't you take a stand
Which stand as in?
as a witness?
I am not compelled to. I did say that I'll give evidence, but I did not give evidence because they could not prove the case. That would be my humble submission. My lord, there's a concept in 1953 itself, it is said that when a prosecution alleges a sequence of events that has happened, they have to go through the entire sequence. They have to prove the entire sequence. Now, here, what the PW1, he's the star witness. He's the only witness because PW4, in one sentence, he said, I had seen the incident. Next sentence, he said, I did not see Mirza Begum at that place. So how he saw the incident, God knows. So PW1 is the only person. He states his wife was hit by me on 18/5. Blood was coming out. PW2 came. They took her to Hajo. Thereafter, they took her to GMCH. Thereafter, she was discharged from there and he died. Now, if that is the entire sequence, what is proved? Only that she has died. Entire treatment, whether even the fact that it has happened on 18/5, nothing on record. Could have been done on 18/4/2007. Could have been done the previous day also. First, it has to be proved by something that an injured person had come to Hajo primary center with certain injuries on the head. That is on 18/5. And the Hajo center has sent the person to GMCH for better treatment. You go there. Then GMCH has to say, yes, she has come here. She was discharged on 29/5 and thereafter she left. Not even the attending doctors who had treated her. Nothing on record, my lord. Not a single document is on record that she was taken to Hajo and GMCH. Not even the discharge summary.
Citation?
Now this 53 judgment. There's just one line I would like to point out, my lord. So, Lord, oh, that's right. 1950 SCC 673. My lord, now what the SCC does, they had Xeroxed all those old AIR citations
Okay.
and then brought it in. Actually, it is 1953 AIR. I'll give the AIR citation.
So because this started only 69.
69. But now they have everything. Even some Privy Council decisions are also in SCC now. My lord, paragraph 18. 953 is not one message person. In a case where death is due to injuries or wounds caused by a lethal weapon, it has always been considered to be the duty of the prosecution to prove by expert evidence that it was likely or at least possible for the injuries to have been caused with weapon, with which and in which manner they have alleged to have been caused. It is elementary that where the prosecution has a definite and positive case, it must prove the whole of that case. Now, here the case of the prosecution is that she was taken to Hajo, GMCH, treated, and thereafter sent back. Now, the AIR citation is AIR 53 SC 415. This is the same citation. 53 SC 415. There, I guess, my lord, it was paragraph 12 or 13. Maybe 415. Now, the other compilation, other judgments.
Yes, that is a very small judgment, hardly anything.
Yes, no. This I got this morning. Suddenly it came to my mind. But this is the compilation that we made. Well, the first point is on delay in lodging FIR. I'll read paragraph 30 at page 15 of that compilation, 15.
Yes.
2016, 9 SCC, page 1.
Paragraph
30. at page 15 of the compilation, 15. 30. Delay in lodging the FIR often results in embellishment, which is a creature of an afterthought. On account of delay, the FIR not only gets bereft of the advantage of spontaneity, danger also creeps in of the introduction of a colored version or exaggerated story. In our opinion, such extraordinary delay in lodging the FIR raises grave doubt about the truthfulness of allegations made by respondent 2 wherein against the respondent appellants, which are in any case general in nature. We have no doubt that by making such reckless and vague allegations, respondent 2 herein had tried to rope the appellants in criminal proceedings. We are of the confirmed opinion that continuation of criminal proceedings against the appellants pursuant to this FIR is an abuse of process of law. Therefore, in the interest of justice, FIR deserves to be quashed. In the context, it is apt to quote the following decision of the court in Jaiprakash Singh versus State of Bihar, wherein it was stated, the FIR in a criminal case is a vital and valuable piece of evidence. Though may not be substantive piece of evidence, the object of insisting upon prompt lodging of FIR in respect of the commission of an offense is to obtain early information regarding the circumstances in which the crime was committed, the names of actual culprits, and the part played by them, as well as the names of the eyewitnesses present at the scene of occurrence. If there is a delay in lodging the FIR, it loses the advantage of spontaneity. Danger creeps in of the introduction of colored version, exaggerated account, or concocted story as a result of large number of consultations, deliberations. Undoubtedly, the promptness in lodging the FIR is an assurance regarding the truth of the informant's version. A promptly lodged FIR reflects the first-hand account of what has actually happened and who was responsible for the offense in the question. And the second point I want to is the carbon copy is not an admissible evidence. It is 1997, 6 SCC, page 171. My lord will find it at page 28 of the compilation.
Page 20?
28. Well, 18 is the facts of this particular case. I want to rely on that. However, the most glaring infirmity appearing on the record relates to the evidence led by the prosecution to prove the homicidal death of Khurshid. The only witness examined by the prosecution in this regard was Satish Kumar PW 21, a record clerk of the district hospital Ghaziabad. His testimony read as follows. I have brought the postmortem report of an unknown male sent by so-and-so. Was conducted on by Dr. U.C. Gupta. The date of sending is not known to me and is not given on record. Dr. U.C. Gupta was transferred from district hospital earlier. He has now been transferred, this, cross-examination. Original copy is not on record. The original copy is sent to SSP Ghaziabad. Second copy is sent to police station. Third copy is maintained in the record. Paragraph 19. It passes our comprehension how the trial judge entertained the postmortem report as a piece of documentary evidence on the basis of above testimony of a clerk in spite of legitimate objections raised by the defense. In view of section 60 of the Evidence Act referred to earlier, prosecution is bound to lead the best evidence available to prove a certain fact. And in the instant case, needless to say, it was Dr. U.C. Gupta who had held the postmortem. Here, the same person has come. It is, of course, true that in an exceptional case where any of the prerequisites of section 32 of the Evidence Act is fulfilled, a postmortem report can be admitted in evidence as a relevant fact under subsection 2 thereof by proving the same through some competent witness, but this section had no manner of application here for the evidence of PW 21. Clearly reveals that on that day he was deposing, Dr. Gupta was in the hospital. The other reason for which the trial judge ought not to have allowed the prosecution to prove the postmortem report is that it was not the original report, but only a carbon copy thereof, and that too not certified. And that's why I'm saying here the seal, the seal is there of the doctor, but after that seal, his signature is not there. Could have been a Xerox copy or carbon copy, but he has to certify it. And the next point I would like to urge is attending doctors were not examined. But this is an unreported judgment of this High Court where I had argued this point. My lord, paragraph, page 48, my lord, of the compilation. Here also, my lord, in this case, what had happened? There was a hacking injury. The person was taken from one hospital to another. He had died in the GMCH, but the person who had stitched it in the first hospital, that doctor was not examined. Paragraph 30, my lord, at page 48. The prosecution did not examine the surgeon who did the surgical operation upon the deceased, or nor examine any doctor who treated him during the time the deceased was in the hospital. In the absence of such evidence, it is difficult to arrive at an unhesitant view that the genesis of the death of the deceased was the assault allegedly inflicted on him on the date of the alleged incident. No weapon of assault was recovered by the IOS during the course of investigation, and there is no medical evidence as regards use of any weapon which ultimately led to the death of the deceased. Here also same facts, my lord. No weapon recovered. Only Dow is mentioned, but first and foremost, my lord, there's a delay of 12 days, unexplained delay. I understand, my lord, even if he does not explain, I understand that he was going around with his wife. The PW2, she is also relative. The
He
deceased,
was going around with his wife?
no, they're taking to hospitals and all. That's what I meant for treatment. The PW2, she is also relative. She stays nearby. Lodging an FIR, just they didn't to put the information. If that is not done, I understand. The fact that she had gone to Hajo, the fact that she was taken from thereafter, directed to be taken to GMCH and released, nothing on record. So whether the incident as alleged has at all happened on 18/5. That's my humble submission. My lord, if we calculate, she was on bail during the trial, but as of now, her total incarceration is 8 years, 3 months.
Yes, madam.
First point raised by my learned friend, that the delay in lodging the FIR, your lordship. Of course, there's a delay, but it has not been explained as it would have been, your lordship. But because lordship, since his wife was in the hospital, your lordship, probably for that reason, the delay has occurred, your lordship. And whether the evidence of these two witnesses, lordship PW1 and PW4, lordship will take into account, can this witness be taken as a starling witness, your lordship? May I take your lordship to the evidence of PW1? I'll read it slowly.
No, one though basically,
Yes,
to the effect that he saw his
Yes.
daughter-in-law hacking her
Hacking.
mother.
yes,
Okay,
yes,
that is all right.
yes.
PW4 is not an eyewitness.
She is. Why, your lordship?
Ah.
So I wanted to read evidence of PW1. The accused of this case, named Mirza Begum, is my daughter-in-law. This is Hassan Banu, was my wife. About 6-7 years ago, Hassan Banu died around 9 AM on the day of incident. I was milking the cow. My deceased wife, Hassan Banu, was holding the calf near me. At the time, my daughter-in-law, Mirza Begum, came taking a dao in her hand and hacked on the head of my wife, Hassan Banu. Then I left the task of milking the cow and held my wife's head. After hacking my wife with the dao, I saw Mirza running away from the place of occurrence. Thereafter, my neighbor Khateza and I lifted my wife to a sumo vehicle and took her to a medical so and so. Russia, of course, she didn't see this one accused person, the place of occurrence. So may I again take your lordship the evidence of PW2? I know the accused of this case, Mirza Begum. Informant Samir Ali is the elder brother of my husband. This is Hassan Banu, was the wife of Samir, and she was my sister-in-law. Mirza Begum is the daughter-in-law of Hassan Banu and the informant. The incident took place about 5-6 years ago. Around 10 AM on the day of the incident, I was in my house. The house of the informant is situated near my house. There's another house in between our houses. At the time of the incident, I was in my house and hearing he went trying the house of the informant. I went there and saw that my sister-in-law Hassan Banu was lying there with injury in her head. My brother-in-law Samir Ali said that Mirza had. So, lordship, of course, he is correct in saying so. PW2 cannot be taken as an eyewitness. So, what remains the evidence of PW1? Whether the evidence of PW1 was challenged by way of cross-examination, your lordship will take into account that.
Madam, there is one aspect. Someone has hacked
Yes.
your wife or your husband. You take her to the hospital, okay. But then, why couldn't it have been reported? You're not going to be there with their wife. If it's life-threatening, they're going to be in IC. You could have complained the next day to the police or the day after that. There is nothing to show the injury that had been inflicted upon the deceased. at that relevant point of time. When
There's
she was-
nothing. Yes, I admit it, there's nothing, your lordship.
Yes.
Whether it is fatal to the prosecution, your lordship will hold that.
That is,
Lordship,
that-
yes.
no, so the thing is that, what were the injuries to the deceased at that time? That is not there at all.
But your lordship will take into account the doctor's evidence, which says that victim died as a result of injuries sustained by her.
Now, was it the same doctor who treated this patient? The one who did the postmortem
My lord,
examination,
Lordship.
did he treat this patient 12 days back? How does he know?
This is a autopsy doctor, your lordship.
Hey, but
Yes.
how does the autopsy doctor know?
From the,
From-
from the,
from-
seeing the injuries, your lordship. So lordship will see,
Let us see the injury.
yes,
Let us
my
see
lord.
the-
PM report, is at page 42 to 47.
No, let us see his, okay, 42 to 47, let us,
Just, lordship, I'll take you to PW3 then.
no, it's okay, 42, let us see.
42, 43, my lord, a female dead body of so and so wearing, not needed.
Number-
A cranium and spinal cord, scalp as discussed, skull cut of right parietal and occipital bones, my lord. And 2 is wound's position and character. An old stitch wound over the right temporal parietal occipital region, 18 cm in length. Then on page 44, membrane cut at right parietal and occipital regions. Subarachnoid hemorrhage in right side, cut of right occipital lobe, spinal cord not examined. Lordship, then cause of death, my lord, opinion of the doctor. Death is due to coma as a result of the injuries to the head. Described the injuries are antemortem caused by heavy sharp cutting weapon and
He was released from the hospital.
my lord.
He was released
2 days back.
2 days
2
back.
days back.
So she went into a coma again.
Lordship,
How does he know she went into a coma?
maybe from the symptoms, your lordship.
No, because he saw a dead body. He didn't see, you see, what symptoms will there be?
Lordship, as the
In a coma, when he comes out of a coma, what symptoms will there be to show that he's been in a coma?
Lordship, I'm not an expert.
No, no,
Expert is
let us
six-
know, even us, let us see. You see, now the thing is that a person out of a coma might be thin or whatever.
No, even lordship.
But that will not, there is
Yes.
no proof that he was in a coma. You see, in this case, this lady was cut by the appellant on 18th.
Yes.
Then apparently, as per the husband
My
did
lord.
not report the matter to the police
Yes.
anywhere.
Yes.
There is no doctor's medical or hospital medical certificate from 18 onwards at all. The only medical document that is available is the postmortem
Postmortem.
report.
Yes, my lord. True.
Now, how do we know that the injuries mentioned in the postmortem report were there on 18? Or on 19, or on 20, or on 21?
Lordship,
Or
I'm
it
handy
have been done.
record.
You see, your entire case is based on the evidence of PW1, who says that his daughter-in-law killed his wife. But he never reported to the police. He never, there is no doctor's evidence, no hospital certificate, nothing for that entire period. And then you say that on 29, she was released from the hospital and on 30 kilo. 29, why should she be released? Where is the release order? There's nothing.
There's nothing.
It's only the evidence of this person. There is no weapon. Why didn't he report straight away on 18th? Okay, because he had to go to hospital. Okay. But what about 19, 20, 21, 22, 23? None of them. Yes, they would have yes, with the injury that if it was very serious, the hospital itself would have filed a report. It was their duty to make a criminal report.
Lordship.
This gap between
Lordship,
the-
I've come across a document,
Ah,
Chalan, my lord,
ah,
page 50, exhibit
50.
6. Deputate with so and so to proceed to the above noted place with government in uniform and report before Superintendent Police Sergeant GMC's Bangagars, Guwahati to conduct PM to start.
Oh,
him.
this
Or
is
maybe
after death.
conducting
This is after
PM.
the death.
Lordship, after the death.
There is nothing between 18th and 30th. 18 and 29.
Problem is, though he has said she was returned on 29, if we go by his evidence, in his evidence, he says she came back, stayed for 2 days at home, then died. And PW2 in her evidence says she was discharged from hospital, stayed at home for few days, and then she died.
2 days includes a few days also.
I understand, my lord, but it's specifically, I'm saying that 29, whether that vagueness is always there. Plus, my lord, I forgot to mention one
You
thing,
completed, then I'll start.
just to clarify.
Manakar, you proceed.
My lord, just one thing, whether PW2 was
This lady came back on 29.
in the FIR, he says on 29.
If I could.
FIR, he says 29, but in evidence, he says 2 days she was home. And the date. My lord, if your lordship takes page 53, there's a sketch map. My lord,
Ah.
all the houses are mentioned there.
Ah,
Who are the neighbors and all. This does not say about the house of PW2. She says she's a neighbor. She came after hearing the sound.
53.
The description of the houses is at page 54. It states PW2's house is not named and her husband's name is Sadiq Ali. That is also not named. So whether she was actually, used to reside there.
PW2's evidence, I am not saying she's taken to be an eyewitness, my lord. I've already made the submission.
no, the thing is that she said that she heard the quarrel, no?
And she took to medical college, GM,
Yes.
Hajo.
So to hear the quarrel, either she was roaming around that area or she should be a neighbor.
So I said, lordship, since she is not an eyewitness, she has witnessed the occurrence after injury was lordship made to the victim, and this is lordship, accused person is also not at the place, was not seen at the place of occurrence. So I made the submission, the inception, lordship, only the PW1, which can be lordship, can be whether he's,
That Ms. Green,
Yes.
because PW2 in her evidence
yes,
said, I was in my house and hearing who and cry in
Well-
the house of the informant, I went there and saw.
yes.
So on that part.
Yes, and PW2 says, my lord, there is a house in between, my lord. The house of the informant is situated near my house. There's another house in between our
What is
houses.
the informant's name? Informant's name is?
Samir Ali.
Samir Ali,
Samir Ali.
PW1. He's the husband.
Sketch comes.
No, nothing, there's nothing. There's nothing. Nothing. He's married, the appellant.
Yes. She has three children.
Why didn't the appellant's husband give some evidence or something?
My lord, it's like giving evidence against his father, maybe. I don't know. But yes, she has 3 children.
That is a different issue. Let her have 20 also. Let
I'm
her
just
have
informing, my lord. She's married with 3 children.
nothing that.
She was a daughter-in-law of that deceased. So obviously she has to be.
The problem is, why didn't you see, there was so much time to inform the police,
I
not
completely.
only by the informant, but also by the
Doctors.
hospitals, the various.
Exactly, my lord. That casts doubt on whether this thing actually had happened. Whether she was even taken to GMCH or Hajo.
Or maybe you see, the thing was that maybe the injury was treatable. But since died eventually. Then they
That's
said,
why
"Ah,
she
right."
could be, my lord. But
Could.
even in that case, my lord, she was taken to Hajo, then to GMCH. Something was done there. Some treatment was done there.
Lordship, I'm so sorry. Lordship, I have perused the original charge sheet. Here, the name of PW2's name is my lord. Kinam?
Khatejan.
Hattez, no, I don't.
PW2 Khatejan. Khatejan.
Khatejan Bibi.
Khatejan Bibi. Khatejan Bibi.
Yes, and four is the eyewitness, no?
Surejan. Surejan.
So she's the eyewitness.
I দুটা কথা কৈছে এবাৰ দেখিছো কৈছে এবাৰ নাই দেখা কৈছে My lord, PW4, an alleged eyewitness, if your lordship takes page 16.
She has said she has not seen.
My lord first said I have seen, then said not seen. So she's not seen.
So clear.
Yes, yes, my lord. Yes.
No, that is just, I think, translation problem.
Maybe, my lord, but she has not seen.
No, no, it's a translation problem.
Lordship, Khateza Bibi,
Two, PW2.
PW2, wife name is, husband's name is Sanser Ali. Sanser Ali. Lordship, the sketch map it is showing as Sansil.
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 Okay.
Lordship, in the original chart sheet also showing as Sansil, and Sansil's name is shown in the.
Oh, then my lord, I retract that. Because in the
Like-
translation, it says Sadek Ali.
How does it matter?
No, like as my learned friend made a
Because, yes,
query,
yes.
whether she could hear the sound.
Yes, you heard.
Yes,
Yes,
yes.
yes. So that much is all right.
Yes.
But then the problem is, even they should have been curious as to why no police report it. The only thing like the hospital should have made it. Or they might have told a lie to the hospital people also. That he had fallen down and somehow injured herself or something. After some. No, I think that it was very bad. But they thought that it was not a very serious, and so let's lie to the police or to the hospital. They all speculated.
Lordship, there are two factors. Whether this PW1 had any enmity with this one accused person, nothing has come up on record. Why would he implicate his own daughter-in-law? Lordship, his son was also there, your lordship.
If he doesn't want to tell us the reason, how
And when
can we help it?
lordship, when eyewitness's account is there, why he
Which
should be?
which eyewitness?
PW1 is the eyewitness.
PW1's actions do not show that, does not appear to show that he's a reliable eyewitness. I mean, he's a reliable.
Just because his lordship, there's a delay, my lord. And
Madam,
procedural part, my lord,
Madam, there's not only a delay on his part. There's a responsibility cast upon the hospitals, the doctors who treated
yes, your lordship,
And
that's
the
the
pro-
lapses in the part of the
Madam,
prosecution, my lord.
prosecution. So you have got to prove your case. Where is the medical report or the medical certificate issued by the hospital showing how they treated this lady before her death? What was the injury?
Only on that point, your lordship. Other, I have got citations as regards delay, as regards your lordship, other ground, the person died after so many days. I have got judgments in my.
That is all right.
Yes, as regards the non-examination
Look,
and.
look, if supposing there was a report, either by the hospital or by the police, that so and so has occurred on this day, and the death subsequently occurred some other day, maybe we would have said that okay, everything now connects. But here there is no connect, no.
In between, there's a gap.
There-
Lordship, may I be granted
For what?
this time, only on that point, whether it is fatal to the prosecution, non-examination of the treating doctor.
No, not that. Where are the gaps have to be filled up by the fact that this because of this injury,
Yes, so I have
After
that judgment.
4 or 5 days, no?
I have, to that effect, I have got the judgment.
6 days.
No, no.
Yes.
18, then
12 days delay.
days.
20, the deceased died after 20 days, I have got a judgment to that effect.
No, that's not the issue.
Yes,
What?
The issue is whether there was any real injury
so your
on
lordship,
the basis of that, or the basis of the action.
yes,
of
your
the
lordship,
appellant.
I understood. Lordship, whether it is fatal to the
Yes,
prosecution
it is
case.
fatal.
Lordship, let me take, Lordship, I'll do some research on
It is
that.
very, very fatal. There's no connect. This is a blank. Supposing
Research on that.
tomorrow somebody files a FIR. Oh, Justice Michael, around 20 days ago, he hacked somebody. He hacked my wife, and then she was taken to hospital. And then, but she died yesterday, so we're filing FIR today. Now, what do you have for, now you're going to ask, okay, what did you do 20 days ago? Where is the hospital report that that person had injuries of such a nature that it required hospitalization and it required medical treatment?
Lordship.
There is no medical treatment, nothing is here.
First, they have taken a plea as regards mental insanity, if I'm not wrong, in this matter.
My lord,
They could not
under
succeed,
defense,
Your
I can
Lordship.
take 101 pleas.
You can,
I can take.
thousand pleas
Whether
you
it
can take.
sustains or not, it doesn't matter.
Lordship, let me get some,
Prosecution has to.
yes, beyond all reasonable doubt. Since doubt has arisen in your Lordship's mind, let me take a daytime, Your Lordship. Tomorrow it can be
Issues
taken
are
up.
contractual. Here, the context.
Lordship is very much correct. So let me do some research. Because the Lordship lost lapses on the part of the prosecution, the criminals will like it.
I have a
They get
judgment
acquittal.
exactly on that point. I just took it out. 2019 judgment, it said
There are
defect in
judgments.
prosecution, benefit has to be given to the accused. It's
Not
a
only
case, it's a
2000,
case
there
where
are
a custom
judgments.
officer was killed.
No, but you see, all crimes cannot be proved.
No, no.
Let's be very clear.
Lordship.
And all prosecution will not be 100% perfect. There will be some lacuna here and there. But that doesn't mean that,
It's a serious lacuna on the part of the prosecution, my lord.
yeah,
Regarding, yes,
yeah,
yes, Lordship is very much correct.
Improve
And how
upon-
the Supreme Court has hold,
to improve upon it. You see, it's not a question of law here.
my lord.
It's a question of fact. If it is some minor discrepancies, minor contradiction, that can be overlooked. But here it goes to the core of the issue as to what was the injury in the first place. Is it that how do you know? He might be making up a story also.
True.
That-
But she got a chance in Trivandrum. She could have said,
No.
I did not kill.
That's what she said.
I falsely implicated. I said, I falsely implicated.
She said, where are the facts against her?
Yes,
In the
so
PW1.
my father-in-law had an enmity with me regarding so-and-so dispute. So he has falsely implicated. Nothing has been.
Why does it, when there's no, supposing there's no enmity, then you mean to say that it still proves the case? No, that is only one of the factors.
If your lordship grants me a daytime, it's up to your lordship, my lord. Only on this point, my lord.
Look, if you can improve upon the facts, it's okay.
I'll go through it once.
How
I'll leave
do
it to
you-
your lordship.
How will you improve the facts? This is our question.
And I did not find anything in the records also.
That is what, because there's nothing here. You see, there's no reason to believe only the PW1 without any supporting fact. In fact, his evidence is to support the facts. There's nothing.
Only give me, lordship, please to give me 5 minutes. I'll go to the entire records.
Okay, we'll give you till 2 o'clock.
2 o'clock.
2 o'clock.
Yes.
Yeah, very well. And we cannot, supposing we convict on this basis, imagine the damage it can cause to others.
What is some?
Yeah.
Yeah, please, your lordship.
So you're challenging the sentence.
Sentence, lordship.
Now, what is the conviction was made under which section?
120 and 38 of the UE.
120.
120.
Let us see the section.
120B, L, section 38.
One twenty B IPC and 38 of the NIS.
Otherwise, it is quoted in the judgment also.
Oh,
It's quoted in the judgment also.
okay, 120 feet. 120 feet.
Punishment for criminal conspiracy. You will take come here.
Yes, that is still there, okay, in the act,
And
the
the-
judgment.
in the judgment, Lordship, it's quoted at page 15.
That is for 120 feet.
Yes.
What about 38?
38 is also quoted, Lordship. Let me just read 38, Lordship.
Not here, I don't think 38 is it. It is not quoted.
Lordship, in the main act, Lordship, then it is with relation to Lordship being a member of a terrorist organization.
Yes,
If I may just read, Lordship.
38, yes,
A person who associates himself or professes to be associated with a terrorist organization with intention to further its activities commits an offense relating to the membership of the terrorist organization, provided that this subsection shall not apply where the person charged is able to prove. So able to prove we are not here because he has admitted. A person who commits the offense relating to membership of a terrorist organization under subsection 1 shall be punishable with imprisonment for a term not exceeding 10 years or with fine or with both. Now, what has happened here is, Lordship, after the charges were framed,
yes. But it gives only 10 years, doesn't give a minimum sentence.
no, it does not give the minimum sentence. It says it may extend up to 10 years. Now, the charges were framed on 26/6/2023. On the very next date, that is on 9/7/2023, they filed applications pleading guilty. And on 26/7/2023, the judgment was passed.
Yeah.
Now, Lordship will consider that pleading guilty is not a license to getting a lesser sentence. Pleading,
But pleading guilty also does not mean that you should get a very serious sentence.
no, Lordship will just give me 5 minutes. Yes. Here, Lordship knows that the UAP Act and the amendments made thereto, particularly if we look into section 38, that deals with terrorist activities, membership of a terrorist organization, something that has got to do with the sovereignty of the country. Under those circumstances, are we going to give them the most lenient punishment?
But the parliament in their wisdom has allowed it.
Yes, Parliament in their wisdom says may extend to, but what was the consideration for giving the punishment? The punishment is whatever the period he has already been as a UTP. The period that he has spent as a UTP, that is what? And can the,
That can be allowed also. It is part of the thing, it's part of a sentence.
it's part of the sentence. Now, if a person is convicted for a longer period of time, now Lordship will also have in mind the period a person undergoes as a UTP, that is not RI. That is SI. That is not RI.
So does it say out here that the sentence has to be RI?
Yes.
It is. No, it is. No, where? Oh, okay, it is.
It's RI. So the,
So,
now, had it been a longer sentence, then it would
Oh.
have been, the period already in custody would have been set off. Now, under those circumstances, Lordship, what are the conditions that were in the mind of the judge? Because primarily, when a sentence is given, there are some mitigating factors, aggravating factors which are to be in the mind of the judge. Now, simply because I say I admit to the charges. Firstly, if I admit to the charges, I admit to the whole charges. I am a member of a terrorist organization. I'm pleading guilty to that. Now, while considering that, if your lordship will come to the charge sheet, because now your lordship has to consider only the charge sheet because the materials that were there before the court at the time of consideration of the guilty pleading application was the charge sheet because the charges were just framed. Here, if I may take, now these, so far as the A4 is concerned, he was the person who was in the recruitment of the Maoist cadres. He was the conduit between the A1. A1 was their lordship, you may say their boss. A1 is undergoing trial. A5, who is the opposite party here,
give us some judgment
lordship.
with regard to the appellate court can give a harsher punishment than what has been prescribed by the court.
Appellate court lordship, I have got some judgments how it has to be considered.
How consider
It has to be considered, yes.
because out here at the
I-
what we can know, what we like we said, rigorous imprisonment for the period already undergone
Yes,
would have to be rigorous imprisonment. So it cannot be UTP.
it cannot be UTP. That is what.
So there is some
Had it been lordship from today,
Uh,
well,
some contradiction here. So is it possible for us to set it aside and send it back for fresh sentencing?
on the face of it, lordship,
Won't that solve the issue?
that can solve the issue, lordship.
Because otherwise we have to direct you to undergo a rigorous imprisonment for the period.
The trial court can have a relook at the matter, lordship.
Because we'll have to set aside the sentence,
Yes,
not, no. That is one way of looking at it.
yes.
We'll hear you.
I
If you have-
would be very happy if your lordship
That's that.
gives it to the trial court because apparently on the face of it, yes, there is some mistake here.
Yes.
And how it has to be considered, lordship.
We'll
that
just
was
hear
the-
you on one aspect. We'll just ask him one, because there's no time, just. Yes, so the thing is this, he's saying, the period undergone as a UTP is not RI. But the conviction has been given for RI. Sentencing has been given for RI. Now, if that be the case, that means the sentencing has not been undergone by you in one way. So is it possible that we set aside the sentencing and direct the trial court to pass a fresh order for sentencing?
If that RI was not there, then things would have been otherwise.
Normally what happens, if a punishment is given in RI, whatever sentence already undergone as EPP is set off.
Can be set.
It can be set off. It is normally done, since we have.
Already done, okay, but since the issue has been raised, now we will have to address the issue. Normally done will not work now.
Right.
We have, if it can be done, okay, take it. But whether it can be done is the issue. So you'll have to now make your arguments on that. Mr. Bhattacharya, any idea?
The set off is generally done. The lordship takes up any POXO matters. In the first part of the judgment, it says that there's so much so days he or she has been inside under 428 section, I guess. Well, and 428 of CRPC should be. set off.
Anyway, no, it usually done is not an issue here. What we are, since the issue has been raised, we have to see that. Here, we set up, the sentence are Okay, we'll take it up at 2. Okay, or everything at 2. Only one thing, that section 428, whether to cover your case or your case. Just that aspect. And those judgments will still want it. Okay.
No, sure, I've gone. Didn't find any.
Very fine.
Side citation, 35. Will be when the one.
Okay, for
Will be.
on how many? One is
What
for
about this?
late
And one for victim that have to pay fees.
victim. Paragraph is given. Okay, in that item.
Five. Item.
Five. You'll be there, so that will just dictate. I will try to fit at least the main, the fact.
I'll just play the defect in prosecution. I'll just place one small judgment. Your lordship.
Then it will be that.
Obliged.
At 2.
Oh, sure, I mean.
Okay, you don't need to remain. He'll be there.
I'll be there.
My learned
What
friend
is
is,
this item?
yes,
Item one,
item 1 that,
the order was being dictated.
What was it?
Your Lordship,
11 months, she's right, 11 months.
Your Lordship, it is 72,000 actually, 12 months because.
No,
Yes.
actually, since till January 2026, it's 11 month. And February, it will due accrue on 10th of February.
It accrues on 20th of February.
11
Your
months.
Lordship- No, Your Lordship, 12 months.
Why?
Reason being, Your Lordship may just see the order.
I don't have the order. I will say it's
Yes, Your Lordship,
somewhere in this.
to kindly read it.
Ah.
The interim maintenance order shall be effective from the month of August 2023,
Yes.
Yes.
and opposite party shall pay it, the amount within 10th day
No,
of
it'll
every
be- it'll
successive.
be- it'll-
It's 30
it'll
months
be
till
from
January.
September. It'll be on September.
No, Your Lordship.
Order was passed on 31/8.
Yes, Your Lordship, but it clearly states that the maintenance order shall be effective from August 2020.
Okay, August 10.
And the opposite party shall pay the amount within 10th day of every successive month.
Okay,
So it is 30 months up to January 2026.
okay. 12,
If
12 months or 30?
I mean,
No.
Lordship, till January 26, it is 12 months. If
You-
we
if-
count
Your
February,
Lordship, I've just-
then it will be 12 months.
12 months.
Yes.
Madam, 12 months or 13 months?
12 months, Your Lordship, 12,
Months.
72,000.
If you are
No,
counting February,
not counting February, till January. From
If you're
August 23,
if you're counting February, then it will be
13 months.
12 months.
No, from August 2023. I've
13 months. So today is what date?
Today
this
is 5th.
said, so Your Lordship, till January, it's 12 months, which is why I'm saying it's 72,000.
Huh?
It's 70.
12 months.
12
12
months.
So you are the one. Tell him 12 months. 12 months. That's all. 12 months at the rate of, so we won't say the amount.
Well,
11 is 12. That's all.
well,
This was.
Your Lordship won't mention the amount. If
No
Your
need,
Lordship-
no need. You want me to mention?
Yes, Your Lordship, 72,000.
72.
72,000.
72.
72,000.
12 months at the rate 6,000 per month. Look out.
Within 1 month you pay.
Yes, madam. I have given the instruction, she'll pay. Obvious.
Much obliged.
Okay, third, Mr. D.K. Bhattacharya, learned counsel for the appellant. And Ms. B. Buyan, learned APP for the state. This is an appeal against the conviction of the appellant under section 302 IPC. Pursuant to the impugned judgment and order dated 27/2/2018, passed by the learned session judge Kamrup Amingao in sessions case number 208/2014. And the sentence imposed upon her to undergo rigorous imprisonment for life with a fine of rupees 2,000, in default. To undergo
2 months simple,
Huh?
2 months simple imprisonment.
2 months simple imprisonment. Next. The appellant's case is that while the offense was alleged to have been committed on 18/5/2007, the FIR has been filed 12 days later, that is on 30/5/2007. Though the deceased had been cut in the neck, is it? Cut in the neck,
Head.
cut in the head with a dao by the appellant on 18/5/2007, and the deceased taken to two different hospitals.
First, Hajo Primary Health Center, after a GMCH.
Had been taken to Hajo Primary Health Center and then to the
GMCH.
GMCH. Full, huh? Is it? GMCH. And had died after being discharged. Comma. There is no evidence to show that any report regarding the attack on the deceased by the appellant had been made by anybody prior to 30/5/2007. There is also no medical document whatsoever to show the nature of injury that had been suffered by the appellant, by the deceased on 18/5/2007. He also submits that the evidence of the doctor who conducted the post-mortem examination, that is the PW3, is to the effect that the injury, there was one injury on the head of the victim, which was stated to be inverted comma, an old stitched wound over the right tempero, parietal occipital region.
Region. It will be region.
18 centimeters. Then in this one, so you just take page 14. Next. The learned counsel submit that with such serious injuries it was, submits that if any serious injury had been made by the appellant on 18/5/2007, the same should have been immediately informed to the police. However, there has been an inordinate delay in filing the FIR, which raises doubts about the truthfulness of the allegations made by the made by the witnesses and the in this regard, he has relied upon the judgment of the Supreme Court in the case of Manoj Kumar Sharma versus State of Chhattisgarh, 2016, 9 1. Next part. The learned counsel for the appellant further submits that the original copy of the post-mortem report had not been submitted before the learned panel, and only a carbon copy of the same had been submitted without any signature of the maker of the said post-mortem. The same not being, the original copy not having been produced. Comma. The trial judge could not have allowed the prosecution to prove the post-mortem report. As it was inadmissible. In this regard, he has relied upon the judgment of the Supreme Court in the case of Vijender versus State of Delhi, 1997, 6 SCC 171. The learned counsel for the appellant further submit that the who was not examined as a witness, the doctors, earlier doctors.
The doctors who had treated the Hajo and
The learned
GMC.
counsel for the appellant submit that no doctors who had alleged to have treated the deceased during the period between 18/5/2007 to 13/5/2007 had been made prosecution witnesses or examined by the court. He submit that the failure of the prosecution and the failure of the prosecution to no, he submit that the failure of the learned court to examine said doctor
That's para 30 at page 48.
it could not have been proved that there was any serious injury. It could not have been proved that the injury stated in the post-mortem report was the injury that had been received, allegedly received by the deceased on 18/5/2000. Is it? He also submits that no weapon of assault has been seized by the police. Okay. The learned counsel for the appearance submit that where death is due to injuries or wounds caused by a lethal weapon. It is the duty of the prosecution to prove to prove by expert evidence that the injuries were possibly caused by the weapon, by no, what have I said? And the guilt of the appellant would require the prosecution to prove the whole of that case in all respects. Then he submits that when there is nothing to show that the appellant had been the cause of the injury on the deceased. In the absence of any, in the absence of any information being given by the police, by the informant or the doctors of the hospitals in which the disease had been treated, or there was it could not be said that the prosecution had been able to prove the guilt of the appellant beyond all reason. Accordingly, it happens that the appellant should be acquitted of the charge and the section 302. Next, Ms. B. Buyan, the learned APP, on the other hand, submits that. What did she submit? What did she say?
Well, she said the delay in lodging FIR was not fatal.
They submit that delay in lodging in FIR is not fatal to the prosecution.
Plus PW1's evidence is credible. PW1, he's a credible witness.
Evidence of PW1
He's a credible witness.
was enough to convict the appellant as it was as the evidence was credible evidence. In this respect, he has relied upon the with respect to in support of a submission, he has relied upon the relied upon the judgment of the Supreme Court in so and so 2024 2 SCC 557 and 2023 11 SCC 320. That's what. What about what actually relied here? All the paragraph. Not 20 days. Anyway, right. We have heard the learned process for the party. We'll dispose it of, publish. Okay. So we do it, according to. Okay. We are slightly short on time. That is the problem.
Saturday is open this time.
This bench we are not sitting. He has to go for some official work. I've got to also. Huh? No, he doesn't. Otherwise, we can only attend them. If this. No, next Monday I won't be there. No, next week. I'll be coming back only on 17th. Yours is when? 10th. No, but there's only the information. before. Huh? You don't want to photograph. Where is the? Okay, we'll list it again. Not for any other reason, because we've got some problem in disposing number of matters. We'll dispose it off, but let's see tonight, let's see. Tomorrow. List the matter on 18th February.
Will come as part heard, but
Huh?
it will come as part heard.
How is it matter? This is the matter on the.
Published.
Let's discuss it. This is the matter. It send me this file. In my. I'll read now. Yes. Yeah, put this also in the file.
If I may place section 428 of CFC.
420, there. 428.
CRPC.
You can't read.
Four 28 provides period of detention undergone by the accused to be set off against the sentence of imprisonment. Where an accused person has, on conviction, been sentenced to imprison for a term, not being imprisoned for a default of payment of fine, the period of detention, if any, undergone by him during the investigation, inquiry, or trial of the same case before the date of such conviction shall be set off against the term of imprisonment imposed on him on such conviction, and the liability of such person to undergo imprisonment on such conviction shall be restricted to the remainder, if any,
Remainder, not remainder.
if any, of the term of imprisonment imposed upon him. Now, your lordship, the sentence, the period of detention, it is said detention, not sentence, that I have already undergone during trial. It is the period of detention. It has, there is no classification that the imprisonment that I am convicted with is either simple or rigorous. It doesn't say.
No, your sentence says that rigorous.
Sentence says, but this 428 does not say.
Does not say.
It does not classify that only simple imprisonment will be set off.
Correct.
My lord, I have a decision of Tripura High Court Division Bench where the appellant was sentenced for 3 years of rigorous imprisonment. But his period of detention was not set off. He approached the High Court and that was asked to be set off. That is 20.
And has it given reasoning with regard to the issue that rigorous imprisonment sentence would also apply to the period undergone as a UTP?
I have not found it.
The 428 says,
No, we have read
my
428.
lord,
You read
my
it
lord.
1,000 times also same
my
thing.
lord.
We know. But we are asking you, is there any, we are understanding your line of argument, we just want further proof, that's
My
all.
lord, my lord.
You don't have.
I don't have.
What does this, out there, High Court has said what? It has basically said that it should be set off,
It
that's all.
should be set off.
It has not gone into the question as to whether rigorous imprisonment, sentence of rigorous imprisonment would also include set off. That question has not been answered. Has it been answered?
I think it has been because
There are
just 2025 GLT 140.
eight para.
My lord, paragraph 1 is for the sentence that has been awarded to him. This is an appeal under section 374(2) of the CRPC. So and so delivered in so and so by session judge. The appellant has been convicted for committing an offence punishable under section 366. Pursuant to the said conviction by order so and so, the appellant has been sentenced.
Sir, go to the relevant.
My lord. No. The last paragraph, my lord, 38.
So that is all right. That though we understand.
Much.
We just want to know whether in black and white,
My-
if there is anything.
That I have to
changed.
search. Otherwise, the general practice is whatever punishment is given, the period undergone during.
Even we have done it.
Much.
Most probably we have done it.
Much.
But we have not really gone into the issue, that's all. You know, in black and white, that when a sentence is awarded for rigorous imprisonment, that means and includes even a period undergone as a youth.
But the sentence passed in my case, it's very clear. The rigorous imprisonment for the period already undergone.
Agreed,
Again, RI is there. So I need to explain that, man.
that's all. Yeah.
Now, Lordship, so far as the sentencing is concerned, that is all right. Subject to what my learned friend say, I have not got any decision in my hand which would say that it can be done. Now, the effect of this is, Lordship, at best, what we have to understand is he has not undergone any imprisonment. Detention is there. Detention is set off.
That is only
But-
nomenclature, no?
That is,
The effect is basically the same.
no, Lordship, the simple imprisonment and RI, there's some.
No,
Uh,
but
and-
the effect is the same. He's still within four walls. The regime is the same. If he was a convict or a UTP, the same rules apply to him.
Had it been, if I may give an example, Lordship, had it been 2 years, then I could have understood that you minus this part and he undergoes a sentence of the remaining part. That is set off. That can be understood. Here, the question of set off is not there at all because on the date when the judgment was passed, he's free. He is free. Now, what are the considerations?
No, what you mean to say is that the sentence part should always be more than the period undergone. Is that what you're trying to say?
No, what I am trying to explain to my lord is, if it has to be understood as a set off, if it has to be understood as a set off, then it has to be a bit more. only for, it cannot be 0 minus 0. It has to be 2 minus 1 or something like that.
But the intent is quite clear. The intent of the object of what they are trying to achieve is quite clear.
That, Lordship, my understanding, Lordship, I have expressed, subject to what my learned friend says. And let's see how the sentence has been passed, the reasoning, Lordship. Now, if your Lordship will take the Act, that is the UAP Act for a moment. Lordship has read the provision, section 38. I'm just taking a Lordship for one more time. A person who associates himself or professes to be associated with a terrorist organization with intention to further its activities commits an offense relating to membership of a terrorist organization. We are not on the proviso. We have to come to 2, subsection 2. A person who commits the offense relating to membership of a terrorist organization under subsection 1 shall be punishable with imprisonment for a term not exceeding 10 years or with fine or with both. Now, here is the case where the accused pleads guilty. He pleads guilty, that means the rigors of section 38 will come in. He admits to being a member of a terrorist organization with intention to further its activities. And with intention to further its activities, therefore, now the reasoning that has been given by the learned trial court is, if your Lordship will come to the judgment, after going through some parts of the charge sheet, Lordship at page 18, paragraph 14 of the judgment.
Yes.
From the above, it can be seen that neither of the 2 convicts are accused of being involved in any violent act. Their involvement is limited to being members of a proscribed organization, and it appears that they were involved in spreading some activities of the organization, that is CPI, and were also involved in protest rallies and etc. and other logistical tasks, and also publishing magazines for a limited period of time. Now, a person need not commit any violent activity to come within the rigors of section 38. Merely membership is enough. So, the reasoning given that accused, it can be seen that neither of the 2 accused convicts are accused of being involved in any violent act. We are not under any violent act. Yes, they did provide logistic support. Now, coming to the charge sheet which was placed before the learned court below, because at that point of time, the court has to consider only the charge sheet which was before it.
What are you trying to say? That the sentence is not commensurate with the.
Yes, yes, sir.
So it should be more.
It should be more, Lordship, because Lordship will see the objective of the act. It is to secure the sovereignty of the country. Now, if a person pleads guilty, goes out on the first day.
Whether that can be a ground of appeal. When there is nothing to show that the learned trial was not competent to pass such a sentence.
So the competency is not,
And
I'm not
about-
questioning the competency. I'm
When there
questioning
is
the,
nothing to show that there has been any violation of the period of the sentence that can be imposed.
I'm not on that, Lordship. I'm on the reasoning of the learned court below. How a sentence has to be passed. I'm on that. Now, if a sentence has to be passed, a person pleads guilty, a message has to go. It cannot be that it is confined to only him. And this is the act relating to terrorism. Now, on the first day itself, that would be a very good idea, Lordship. Everybody would come and plead guilty on the first day itself. It saves the court's time. It saves the convicts themselves also. Lordship has noticed. Charge is framed on the one day. Next day he files a petition. On the next day he's off. In 3 days he's out.
So
Now,
it can be done.
Lordship,
Yeah.
yes,
Yes, yes.
but I'm not on whether it cannot be done by a court below. It can be done. But what is the message that we are sending to the society? That has also been taken into account. I'll place some decisions on that. Because sentence always has to have some.
Can we, you see, basically what you're trying to say is, we get your point, what you're trying to say. You're basically saying that the sentence imposed too light or too lenient. No, it should be more. Show us judgment which says that if the higher court thinks that, appellate court thinks that it is too lenient or too light, they can impose. The appellate court should impose a more heavier sentence. Because this is a view. Some courts are lenient, some courts are maybe more. But if it's within the permissible limit, statutorily it is allowed. Who are we to say that, no, you should have given not 2 years, you should have given 3.5 years or 5 years. Because we have to justify ourselves. Because you want us to increase the imprisonment. Now you have to show us how we can justify ourselves legally. Not, yes, supposing there was a judge who said that, no, this is also too much, too severe. It should have been lighter, it should have been what, 6 months, it should have been 2 months or half a month. Now, so for that, what are the guidelines laid down by Supreme Court? That you should express that.
So far as a part of the court below, Lordship, I am not questioning. That I'm very
is there.
clear. Now, how a sentence has to be passed, I would be on that. And if the guidelines issued by the Honorable Supreme Court in the Katina of judgments is, if there is a increase in the sentence, the opposite party will have to be first put to notice, and only after hearing them that the court can pass some judgment, enhance it. So my friend is on notice. He is there. He is opposing. And what would be the quantum of increase? I do not find any such. But only line that the Supreme Court has gone into is that without putting the accused to notice, no court will do that.
No, that is all right.
But
You see, the issue is this, you see, I have heard of cases where the minimum sentence is not given. You know, it's less than minimum sentence is given. There, okay, there's not, because the statute provides, so they have to give as per the statute. Now here the sentencing has been done as per the statute, albeit
yes,
less amount of imprisonment. Now, who are we to say Then no. Instead of 2 years, it should have been 8 years. What justification can we give ourselves to enhance that period of imprisonment? That some super judgment which says that, yes, the appellate court can,
No yardstick has been laid down for that.
then you can show us some judgments of the Supreme Court which say that, no, this is too less, it should have been this. Is there any case?
Not that I have laid my hands on, but what are the things that have to be considered
That is all right.
while passing a judgment and a sentence? Those have been laid down, Lordship, in the various judgments. And I would be placing a few of those, Lordship.
And has the Supreme Court then remanded the case back for rehearing on the sentence or something?
Remand I have not come across, but
Then it has it increased the sentence period, saying that no, I'm not talking about minimum sentence.
Lordship,
I'm talking about similar type of provision where the trial court has passed the sentence and the Supreme Court or the appellate court have said that no, it should have been higher.
I have got a contra judgment where the High Court decreased the sentence and the Supreme Court upheld the sentence given by the trial court.
No, it happened. That is a different thing. That is a different thing. We want a sentence which has been increased.
I have not laid my hands on that, Lordship.
No. Anyway, give us the judgment. Because that's the basic thing. That's one thing.
Let's even know. No question. One judgment, Lordship, so far as pleading guilty and getting a lesser sentence, I have a citation from the Kerala High Court, which of course will not bind your Lordship, but has got some purpose value.
Correct?
Uh,
2024 Supreme Kerala.
yes, yes. That's the first paragraph, Lordship.
Yeah.
On the second page, the right to plead guilty shall not be used as a device to get a lesser sentence. In case of pleading guilty by the accused, the court should not adopt a liberal approach, and no concession can be given simply on the reason that the accused pleaded guilty in the matter of awarding sentence. On the other hand, the sentence should reflect a proper balance.
I don't know if you can agree with this because you see, I think the new law even provides where you can concede and then
That's a plea bargaining.
yes, so
That's-
same thing. Plea bargaining is even worse.
No, so,
Even worse.
so this is not plea bargaining.
No, but then that's
This is
the single bench is basically saying
this is not plea bargaining, Lordship.
that they should not adopt a liberal approach. As long as it is within the realms of the statutory boundaries provided, what is wrong?
No, whether all the circumstances
No, and he absconded also. Out here he had absconded also.
Uh,
And the injury was on the vital part of the body. Head.
Lordship may come to the judgment of this one 2004 6 SCC 513. I have given a copy.
2004, 6,
513. It's a Surjit Singh versus Nihara Ram.
Ah,
I would take your lordships from paragraph 5 onwards
yes,
on the second page.
yes.
This is with regard to sentencing. The law regulates social interests, arbitrates conflicting claims and demands. Security of persons and property of the people is an essential function of the state. It could be achieved through instrumentality of criminal law. Undoubtedly, there is cross-cultural conflict where living law must find answer to the new challenges, and the courts are required to mold the sentencing system to meet the challenges. The contagion of lawlessness would undermine social order and lay it in ruins. Protection of society and stamping out of criminal proclivity must be the object of law, which must be achieved by imposing appropriate sentence. Therefore, law as a cornerstone of the edifice of order should meet the challenges confronting the society. Friedman, in his Law in Changing Society, stated that state of criminal law continues to be, as it should be, a decisive reflection of social consciousness of the society. Therefore, in operating the sentencing system, law should adopt the corrective machinery and or deterrence based on factual metrics. Therefore, any undue sympathy to impose inadequate sentence would do more harm to the justice system, to undermine the public confidence in the efficacy of law, and society could not long endure such serious threats. It is therefore the duty of every court to award proper sentence having regard to the nature of the offense and the manner in which it was executed or committed. The criminal law adheres in general to the principle of proportionality in prescribing liability according to the culpability of each kind of criminal conduct. It ordinarily allows some significant discretion to the judge in arriving at a sentence in each case, presumably to permit sentences that reflect more subtle considerations of culpability that are raised by the special facts of each case. Judges, in essence, affirm that punishment ought always to fit the crime. Yet in practice, sentences are determined largely by other considerations. Sometimes it is the correctional need of the perpetrator that are offered to justify a sentence, sometimes the desirability of keeping him out of circulation, and sometimes even the tragic results of his crime. Inevitably, these considerations cause a departure from just desert as the basis of punishment and creates cases of apparent injustice that are serious and widespread. There is another judgment of 2006, 6 SCC 1. State of Madhya Pradesh versus
Santosh Kumar.
Santosh Kumar. Where I will be taking your lordship from paragraph 12 onwards, the discussion then at page 5. In Jashuba Bharat Singh Gohel versus State of Gujarat, it has been held by this court that in the matter of death sentence, the courts are required to answer new challenges and mold the sentencing system. To meet these challenges, the object should be to protect the society and to deter the criminal in achieving the avowed object to law by imposing appropriate sentence. It is expected that courts would operate the sentencing system so as to impose such sentence which reflects the conscience of the society, and the sentencing process has to be stern where it should be Now, this is a case of terrorism.
Agreed. The problem is that the parliament has made the law. The parliament should have said that you cannot give 1 day sentence only. It has not given a minimum sentence. The conscience of the society is reflected in the law made by the parliament because they're the representatives of the people. Now, if they do not lay down a minimum sentence, it says that the provision provides that maximum will be 10 years. So the implication is that 1 year is also can be given, 1 day can also be given, 2 days can also be. Now, who are we to say that 1 day will apply in these cases, 2 days will apply in these cases, 1 month will apply? How are you going to put the bracket when the bracket has not been made by parliament?
Lordship, the law has been enacted by the parliament, but it has to be interpreted by the court.
Correct.
That is what the
But then there
court
is,
says.
so when the court has enacted it, when the court has applied the law,
Now,
what is the illegality that's coming?
whether the materials which were before the court, whether the materials which were before the court have been taken note of by the court in its entirety.
You see one thing, let us go to the section again.
Yes, Lordship.
Let us go to
38.
the section 38.
38.
Let us go to 38.2. That's what you said, 38.2. A person who commits the offense relating to so and so, subsection 1,
Yes,
shall be punishable with imprisonment for a term not exceeding 10 years,
yes, Lordship.
comma, or with fine.
Lordship.
So fine is enough.
There is no fine here.
Correct. So fine is enough. There is no imprisonment required.
Now, taking into consideration what
Now,
were the
so
materials
you can
before the
imagine.
court,
So you can imagine that even fine is enough. You are not the judge.
No.
The judge is there. He has taken a decision. How are we to say, no, you made a mistake? You see, this law has been made by the parliament. If the court has applied the law, if you might have a view that this is very less, but for him, this might be very severe. It depends on which side of the fence you're on.
no, let us take the
And-
other view, Lordship. He pleads guilty to being a member of a terrorist organization.
Okay, according to you, what should be the just sentence?
No, that is for the court to decide. Now,
You are the one who saying it's not
No,
just.
no, what
So we are
was,
asking you,
what was,
to you is just.
what was the court's reasoning? Court's reasoning is that he is not involved in any violent activity. That is not the purport of the section, Lordship.
Well, I mean, you have to, you see, we cannot, you see, the problem is, we cannot impose our view on others when their view is not illegal. And it is in terms of the provisions of law.
So that it may not be illegal, but so far as
Where is it? Where is it in violation? Is it in, the only thing we have got to see whether it is in consonance with law. If it is in consonance with law, why should we substitute our views for their view? There's no infirmity anywhere. Who are you or me to substitute our view when the view taken earlier is perfectly legal?
it is within the bounds of the section, Lordship, but the reasoning given. What is the reasoning given? And what are the factors?
Show us citation in support of your argument. Show us. When we see, it shows that even the most heinous act that could come within section 38(1), if that can be punished by way of a fine, why not this? when they, this is, I mean, it's minor. They've not done any act, like you said.
The section does not require
Ah.
to do any act.
Ah,
Being a member is sufficient, Lordship.
then you don't find anything.
I leave it to your Lordship, but still,
Yeah, we are
I,
trying to- you show us, Abdul, you show us one judgment you show us one judgment by the Supreme Court showing that, yes, a judgment which has been passed and which is in terms, a judgment which has been passed and the sentence that has been passed can be enhanced so long as if the appellate court does not think that it is it is not proportionate to the offense. Trust that.
that I have not laid my hands on. At least
Neither
all the
have we.
reasonings to be given, that is very much there in the judgments that I have given, Lordship. So
Very difficult.
how a sentence has to be considered.
If we allow that, imagine what would happen.
Now, if
Why?
if what is happening, if that is to go on,
So why don't you tell the authorities who can make the law to put a minimum sentence that for a conviction under this sentence, there should be a minimum of 3 years or 5 years or 10 years. But the wisdom of the parliament is not under challenge here.
And Mr. Chaudhary, you are trying to impress us by saying that because he pleaded guilty, he was only that period was given. But in that situation, even fine could have been given. That's the case. Here,
now under the circumstances, if
has been given.
if it could have been otherwise, Lordship. If a fine was there, it could have been a hefty fine. It could have been a hefty fine. Now, a person is out in 1.5 years, he'll go back to his roots.
What to do? That's why you please tell the authorities who can make a difference and who have the same views as you to change the law as you think is proper. Now we are only interpreting the law as it is. We are following the law.
No,
The learned
there
trial
is no question about
The
it.
learned trial court is following the law. Now, just because you think that instead of 1 year or instead of 6 months, it should have been 10 years or 5 years. That is that's the problem. How you see, hands are tied. We have to only see whether the learned trial court has committed an illegality. That's all. Out here we find that he has not committed any illegality.
No,
Only
his
thing is
orders is within the contours of
He
the.
has given a sentence,
But I find the reasoning very.
but then show us a judgment which says that unless a proper reasoning is given for the sentence imposed, that sentence should be relooked into. Show us, give us a judgment. Because out here what has happened is he has admitted to the crime.
Yes.
He has admitted to the crime. End of the matter. So what reasoning is required? What reasoning is required?
On the point of sentence.
On the point of sentence, that is to be challenged by whom?
The Jimma petitions are all, Lordship, familial matters, disease and all.
Is it your case that you should have been given a chance of hearing at the sentence? Is that your case?
No, it's not that.
If that is not your case, then what is it? Because you see, you have got to say that at the time of sentence hearing, we were not given
No,
the opportunity of being.
I won't say that, Lordship.
Then, if you have been given, then what remains? Then the procedure has been followed. We can understand that, yes, it might be too lenient. But then what to do? What to do? How can we say that no, this cannot be done? Very difficult. I think we'll be going into very dangerous uncharted territory if we start overturning sentences which are as per law. So. We can write and then, we can write and then we can sign it off. Okay. Yes, anything else?
Only, my lord, the charge sheet that was filed against me was under section 18, 20, and 38 of the UAP Act. Section 20 is similar to section 38, but section 20 says, if I'm a member of a terrorist organization,
You have been convicted under what?
38,
Only 38.
only
Ah,
38. Now, while framing charge, section 18 and 20 has been struck off. 20, what he has been
Charge was
saying,
not framed under 18 and 20.
18
Charge
and
was framed only under 38 and you admitted to the charge.
exactly.
And so it's only a question of whether his case is that the sentence imposed was too less. So,
Since the minimum punishment was fine only,
not,
and I was
it's
given
set off. Set off. It
Set-
was set off and fine, no?
exactly, ma'am.
Huh?
Has to be set off and fine.
No, it doesn't have to be.
First, what the sentence says,
What was it was, set off and fine only.
because sentence already undergone, they have not stated 2 years, 1 month, and then set off. The order itself says that my punishment is the period I have already undergone.
Okay. Right. Heard Mr. RKD Chaudhary. Then, counsel for the, let's standing counsel for the,
Worship, I appear as a DSG.
okay, for the deputy SDI. For the appellant. Also heard Mr.
B. Prasad,
B. Prasad, learned counsel for the respondents.
the respondents.
So we have got now a reference.
Worship.
So we'll dispose it off. Basically, it's reject.
Worship.
I don't think there's any judgments made. This
I have not.
Okay,
I do one decision, my lord, that if it is manifestly, says,
it's only that part.
only that part, my lord.
No, one part is what manifestly what?
If the punishment is manifestly inadequate. In
That
that,
you say that.
in that case only,
That will be in the circumstances of.
So that might be in his favor.
no matter, because he has to place those facts. He has not placed the facts, my lord.
Para?
Para 15, my lord, last page.
Yes. The question of sentence is a matter of discretion. And it is well settled that when discretion has been properly exercised along accepted judicial lines, an appellate court should not interfere.
So far as the materials concerned, Worship, those are in the charge sheet itself. Basically, logistics support.
Basically that. Issue is basically one issue is whether rigorous imprisonment would also include setup. Number two is with regard to whether we can enhance
Worship.
the sentence and if and when on the ground that we find it inadequate. So that's the only.
Or that he has not placed the facts.
No. That's basically what it's saying.
Mine.
Yes, next.
Cannot be finished.
Yeah.
It cannot be finished, my lord.
Huh?
No.
You've got a good case or a bad case?